If you have any problem, then wait for release of the fund. Why this application? Modification is not.
Clarify so that to avoid the thought. We have filed counter, my lord, everything is ready, but in this case, CCL, my lord, may I please, may I submit notes? I am for CCL. I notice as issued that filed an amendment application that has not been served on me. Whatever instruction I have taken from CCL, that the total work was of 233 crores. And CCL has already paid 210 crores to
Not going to that aspect, that merits of the case now. They have filed an application for a modification. That application is unnecessary. That was just an expectation that in the meanwhile they may pay. This application has been filed seeking modification of this court's order dated 12/2/2024, whereby while adjourning the matter for filing counter affidavits on behalf of the opposite parties, the court had observed that it was expected that the amount which was admittedly payable to the petitioner is paid, in the meanwhile. So stop. Referring to clause 24.1 of the GCC, a plea has been taken in the present application.
Point 2, man.
In the
Point 2. Corresponding payment to
24.1.
Okay.
24.2.
Yes, madam. 2 is applicable. Next page. Page 4.
It has been 24.2. It has been submitted that the petitioner would become entitled to payment only after the NBCC has received the corresponding payments from the client/owner of the work done by the contractor. Stop. We are, however, of the view that there was no positive direction issued to the opposite party number
2 and 3.
1,
2 and 3. 2 and 4.
2 and 3.
2 to 4. 2 to 4. 2 to 4.
2 to 4 to make payment of the admitted dues. So stop. Next. No modification is therefore required. So stop. Your file counsel has
They have not served a copy of the amended writ application on me. They have filed an amended writ application, but not served a copy on me. I will serve it in the course of the day, Lordship.
Why should list this matter on 4 weeks for admission before appropriate bench? So stop. In the meanwhile, the parties shall be required to file their pleadings/counter pleadings and exchange the same amongst themselves. So stop. Stop.
This admission item number 1. In the meantime, the respondent has been regularized, but taking into account his service as Ganasik on completion of 8 years. If she will be regularized on completion of 6 years from the date of training, then she will be regularized in 2001. If as per the policy decision of the Ganasik, she was regularized, she will be regularized from 2017. And because this.
No, but as on date. He,
Your lordship may kindly see that order.
I'm giving that affidavit to with affidavit.
Your lordship may kindly see that order. They have obeyed your lordship's order, but in a twisted manner. Your lordship may kindly see that order. Whatever-
see, had this order been passed on 1st of August
Yes.
or in the month of August,
No, I'm deeply grateful to the honorable court that the lordships.
see, if any grievance remains, then you can challenge that.
My lord may kindly see that order.
Yeah.
Kindly see that order.
Where is that?
My lord,
Annexed A by 4 to my affidavit.
your lordship may kindly see that order. Page 7. In the middle, 7th line from top. Srimati Pramoda Mahanti. My lord has got it. Srimati Pramoda Mahanti, Ganashikhyata, after completion of 8 years of engagement at Ganashikhyata, without prejudice to the claim of others, may be appointed provisionally. My lord, once they decide to do from 2017, why provisionally? They have decided from 2017, and I have, last occasion, my lord, I had addressed your lordship that I have no objection if they do from 17 without recording my concession. But the word they are mentioning provisionally as such and such on creation of post on 1317 in correspondence. So they fix a state, but write provisionally and it will be temporary nature and terminated anytime. My lord, is this a compliance?
Perhaps my.
Is this direction in the, on the order passed by your lordship, which they are seeking a review?
See, if you want to accept it, you may accept it.
No.
If you don't want to accept, don't accept it. Finally, we will be deciding whether if the matter comes to us in contempt or whatever. But if you don't accept, don't accept.
I am grateful that your lordship's indulgence has resulted in this order. I am grateful to it. But my interarguments, even if they are seeking review that it should be from 2017. No, I accept from 2017, but let it not be provisional, so that my entire exercise in coming to your lordship's court number of times will stop. This is my only agreement. 17, I don't have any objection. But provisionally, they should levy.
What is provision?
Her moment lordship annexer B by 4. Perhaps my learned friend has not seen it.
Yes.
We have granted him increment.
I'm only on that word provisionally, not on 17. If they believe that word, no, I have absolutely no grievance before.
No, they may not delete the word.
Why provisionally? Because of last paragraph.
Yes.
Because you do not have city qualification.
OTT. Yes.
No. City qualification also would not do.
She subsequently acquired city qualification. So, for that reason, that she has been given from appointment from 2017.
So,
if that will
so
be
like others, you have to clear this OTT examination. That is why this provisional. Perhaps that is the.
No, OTT, if I pass, my lord, I will get the other increments. If I don't get past OTT, I will not get other increments. But my regularization as a Ganashikhyata will be there. That is not in dispute.
Mr. Please come to paragraph 2 of NSF A by 4.
No. The post so created are created temporarily and under the administrative control of Director of Elementary Education, Orissa ownership. The post will be abolished automatically after the incumbent retires, resigns from services or death.
So when do you retire?
I have not retired.
No, when will you retire?
2008 is his appointment.
Oh no, you are going to retire on 31st. This was the impression which was given to us.
No, madam, I'm not retiring on 31st. I'm not retiring.
now she's 53 years. So he
53 years.
should
I'm
return after 7 years.
retiring now. I have few more years of service to be rendered before the organization.
All right. As you wish. As you wish.
But I'm not on 17. They are seeking a review that it should be from 17 of my lord's order.
See, it is mentioned that purely temporary and this post will be abolished automatically after incumbent retires, resigns. So you will be there. And why should you be removed? And if you are removed for any reason, then
No, in the review, my lord may kindly see the review. In the review, my lord, they are raising one point. Your lordship, by passing the order,
every appointment is provisional, subject to fulfillment of so many conditions.
yes.
As you wish.
No, my lord, I just want to clarify one point. My lord has stated that learned additional government advocate in the order at page 622 of my lord's order which they seek a review. Learned additional government advocate representing the state of Orissa has submitted that the respondent's service shall be regularized in accordance with the government policy, which is more beneficial as to her than what she has held by the Honorable learned single judge. Since according to the policy, from the date of successful full completion of 6 years of service, instead of 8 years, the respondent's service is to be regularized. This was your lordship's order. Now in the review, they raise a point that it should be from 2017. Last occasion when your lordship was heard this matter, your lordship said you first do this, so thereafter we'll decide the review. But on that occasion and today also I am saying, madam, if it is from 2017, I have no grievance. Because I am now not getting anything, I by virtue of your lordship's order, I get something. Let it be from 2017. That provisionally which they are saying, that I am objecting. Not
We will hear your review application. His review application. We will hear them. You recall the order then. You recall this order?
No.
We will hear the review application on minutes.
Madam, with your lordship, I
As you
am
wish.
considering let them pass that, let them make or give us the consequential benefit. I am happy with that.
Consequential, everything cannot be decided here. See, on the previous occasion, you had the only anxiety that you are getting nothing.
Yes.
Now, because of the court's observations, they have passed an order.
Yes. But
Otherwise, they would have stuck to their stand which they have taken in the review application.
I don't dispute this sense. Your lordship may dispose of the review, making it from 2017 without recording my concession.
This review application has been filed on behalf of the state of Orissa, seeking review of an order dated 26/4/2000. Without recording how can we do that? How can we do that? Without recording your concession, how can we do? Either we are required to review or
The lordship.
of an order dated 26/4/2024, passed by this court in WA number 1912 of 2023. Stop. An affidavit has been filed today on behalf of the state of Orissa, bringing on record an office order passed by the district project.
District education officer.
Jagat Singhpur, whereby the sole respondent, number one, respondent number one, has been appointed provisionally as level 5 assistant teacher ex cadre on creation of post with effect from 1/3/2017 in the corresponding scale of rupees 5,200 to 20,200 with grade pay of 2,200 at cell 1 level 6 of pay matrix of ORSP rule 2017. First off. Next. Learned counsel appearing on behalf of the respondent. Number one has submitted that there is no reason why the appointment has been made on provisional basis. So stop. Next, be that as it may, since we are of the view that the respondent number one has been given, has been appointed, though provisionally, we are not inclined to proceed further in the present review application. First off, learned counsel for the petitioner has stated that the petitioner has no objection to her appointment with effect from 1/3/2017. Full stop. In such view of the matter, the review application stands dismissed, stands disposed of. Full stop. We make it clear that the petitioner shall be at liberty to approach this court in the event her services are to be dispensed with by applying the expression provisionally in the appointment letter. All right.
Now, one more clarification. May kindly say one line that they will consider my consequential benefit. This much I am.
Consequential, they will do that.
We have granted in increment.
They have done that.
Yes,
That is not required.
Also, I have to again come and disturb your lordship in another day.
A respondent type an opposite party.
But grateful.
Item number 2.
There are two writ petition, Miller. 15119 and 11629, Miller.
Yes.
11629 relating to refund of
No, why these matters have come?
Miller, both the writ petition were disposed of in a common order, directing payment of money, Miller. But 15119, there is no prayer for money, it is challenging the auction, Miller. Since the party we are saying, and 15119 is to be decided because the result of 11629 has an impact for adjudication of the auction, Miller. Therefore,
Order.
Miller, the final order, you also may kindly see, Annex 2. Furnished in the IO, Miller.
Huh?
The order dated 12/1/24, Miller.
Which order number?
Order number 13,
13.
Miller.
Yes.
Miller, that was disposed of with the observation that this Lordships, both the writ petition having filed by the petitioner paying for quashing of order passed by Tahsildar Talcher in Tauji Niscus number 1 the order of the sub collector Talcher in Tauji Nisapil number 1. Further, it has been paid to direct the opposite parties to refund a sum of rupees so and so. Learned AG has produced a letter dated 11 January 24, issued by the Additional Secretary to Government of Odisha, Revenue and Disaster Management Department to the Collector DM Anugula, according permission for refund of the principal amount of rupees so and so, deposited by the petitioner towards auction amount for Santhapada B. Sandpuri for the financial year 13-14. It is submitted here the sanction in this regard has already been made, but the same shall be disbursed to the petitioner subject to what we want. This order disposing the writ petition is to be recalled because the Lakshmi kindly have a glance.
Recall on what basis?
On the basis of Lakshmi kindly see annexure.
Have you filed any application?
Miller,
What?
for recall of the order.
File review application.
Miller,
IA number 8860 of 2024 has been filed. This application has been filed for a recall of the order dated 12/1/2024, passed in WPC number
WBC number 11629/2021 and 15
Mr.
double
Whether the order is to be recalled in both the cases or in one of the cases.
Miller 15119 of 2021.
15119 of 2021, which was disposed of with WPC number 11629 of 2021. Full stop. We are not inclined to entertain this interlocutory application in a disposed of matter. Stop. The petitioner shall be at liberty, the applicant shall be at liberty to file a review application seeking review/recall of the order. Yes.
Well, both the it's not two ISM, it will also be disposed of also both the cases. There are two writ applications. In two writ applications, interim applications have been filed to recall the order. So this order may be filed in both because both are listed today before us.
No, this order we have passed, this
See,
this order
no,
has been passed in both the cases.
no,
And on the IA.
yes.
Both the cases, two IAs are separately. One is.
Separate applications you have filed.
Yes, separate applications.
You want these orders to be recalled.
Miller, it has an impact on the order because 15119 has never
Why review application? Why is such confusion?
Miller.
IA number 4.
IA number 8860 of 2024 is in WPC number 11629 of 2021. Right. Next one is 8803.
Miller.
IA number 8803 of 2024. Sorry, 8862. So the condemnation also.
8803.
No, sir, condemnation should be 8803 of 2024. Se arata hochi 8805. Condemnation darkar. Jota IA substantive IA. So that is
Miller.
Item number 3.
What is important not pressed man.
Not pressed.
Item number 4.
They are filed for recall all of it in 1940.
File a review application. Why IA?
They have petitioner has filed yours.
Yes, file review application. This is not the correct practice. IA number so and so has been filed for recall of review/recall of the order dated so and so. Stop. We are not inclined to entertain this interlocutory application in a disposed of matter. The
19/4/22.
19/4/22.
or it will be IA number so and so as this application is dismissed. So the petitioner shall be at liberty to seek a review of the order by making proper application.
Miller.
Item number 5.
Organ copy.
restoration application, the dismissal of a writ application for not compliance the direction of the court matter.
High Court, High Court rules. In this case, we shall decide. Mr. Khotia, we were examining the question whether limitation applies in cases of restoration when a writ application is dismissed for default.
My lord,
All right.
my lord.
So there is a direct division bench judgment, very well written, of 1992, which specifically lays down that no limitation applies. So
Subject to, you have to explain the Bhatta Krishna there. Volume 74 CL.
we have to reiterate. They must have forgotten.
In the body of
But here, one of the cases, is we are also part. The limitation then it is true. Only limitation. Thirty days. So this has been explained. After this aspect.
I have not seen this. I have not seen this. We're going to follow that second following.
If there is any other view taken subsequent to this decision is very well written judgment.
Yes.
And it says that law of limitations shall not apply
Right.
specifically.
So to the article 142, 137, both laws, and accordingly said that, so.
once limitation is not applicable to writ petitions,
Yes.
subject to
Restoration will not be lost.
if there is inordinate delay in challenging, then
Then how to-
That is not considered.
Yes.
explain that's
Considered, but not because of that 30 days.
Oh, yes.
So if an application is filed on 31st day
Right.
and the office points out that it is barred by limitation, that is not correct.
Right. Right.
So this will have to be clarified.
Because normally in SR one slip is there, so that has been stated that 30 days limitation, so they are pointing that 30 days limitation.
normally you file IA application
yes,
styling
yes, ma'am.
with an
Because of
application
that-
under section
because of
5
that,
limitation.
we are
That is
filing-
why That is why there is a
Yes.
confusion. Otherwise, if you don't.
And that judgment is clear.
uh,
That judgment,
That judgment is clear.
You have to, one of the plus, I think, prior to has come. That you have to specifically mention which, under which provision you have filed this application. Even if you see review applications, around 47 rule. It is not correct. It is inherent problem. So, unless you see that, the defect will come. So that is why, in order to avoid that defect, being pointed out, the matter to be listed. So that we have to clarify.
Malo, once the defect is pointed by the registry, unless and until that has been,
No,
cleared, the matter.
Even in review, even in review against the writ order, you just file it under section 114 CPC read with order 47 rule 1. So that is also not correct. Because that review power is inherent.
So counsel, if the office points out certain defect which is unreasonable, then you should point out that this is not a defect.
My lord, in this case, my lord, I have filed 2-3 memo for the listing, but due to the defect that could not be listed, that is the reason I filed this IA for consolidation of delay.
So therefore, there should be a general direction that so henceforth the registry shall not raise such
yes,
defect. So we will pass an order for next Friday. Yes.
item number 6.
Your Lordship, item 6, Your Lordship, an IE for modification.
I'll review. What modification? Is there any clerical error?
Your Lordship, as such, there is no demand notice till date issued. Your Lordship, as on date, there is no demand notice in the matter issued. And the order mentions about the demand notice. Lordship, a show cause is to be, show cause dated 13/6/23 is to be replaced.
Where is the, which part of the order?
Your Lordship, para 2, 3, Your Lordship. Para 4, 7th line, Your Lordship.
So seek review.
Lordship.
Seek review of the
So
order.
in para 3,
Para 4, Your Lordship.
you see para 3.
Para 4.
Para 3,
Your Lordship.
you agreed to this order.
Yes, Your Lordship.
Then-
Order dated 28/7/2023.
Consciously we have passed. When you yourself
Order.
read the copy of the order and want us to pass the similar order, then what is wrong in it? You considered.
Your Lordship. Your Lordship, as you pleases, Your Lordship.
IA number so this application has been filed seeking modification of an order dated 28/7/2023 passed in this case. So we are not inclined to entertain this application for modification in a disposed of matter. So this application is accordingly dismissed.
Item number 7.
Oblige.
This current petition is back with Sri Bharat Motor judgment.
We can say,
Yes, Your Lordship, this current writ petition was tagged with the Bharat Mitra judgment and was to be heard with the trial matter. So we appeared before this court and we asked this court to list it separately. Similar order was passed to deal with this current matter and matter was heard to be separately.
Order dated 9/2/2023.
Yes. So when the final judgment was delivered in Sri Bharat Mitra judgment, so we found that our matter is still tagged with this Sri Bharat judgment.
Yes.
So following to that, our SLP was filed before the Honorable Supreme Court challenging that same order with the opposite party, which is the Commission of CELTA, has filed that SLP.
Yes, this is an admitted fact.
Yes, sir. So the SLP was heard.
It appears from the records that despite an order passed by this court dated 9/2/2023 to delink the writ petition from WPC number 13736 of 2017 and to be listed separately in the regular list, comma, in the final judgment, comma, reference to this case, the description of this case also figured in the final judgment in WPC number 13736 of 2017 and batch. When was that decided?
15/3/22.
Yes, it's 23, sir. 15/3/2023.
15/3/2023. So soft. The said final judgment of this court dated 15/3/2023 is under challenge before the Supreme Court. First off, the Supreme Court has as regards present writ application, has made following observation. श्री अजय अग्रवाल से लेकर two paragraphs. So, next, in such view of the matter, comma, the order dated 15/3/2023 passed by this court in WPC number 13275 of 2020 and batch shall not be treated to have been passed in the present rate application. So stop. List this, so since the list this matter,
Your Lordship, I can make few submissions. So I have two prayers for this repetition. One is that a mistake should be, our name should be deleted from the cost total of the order. And the second is that we are, regarding this writ petition, we want to dispose of this writ appeal and we are, let us allow to file the first appeal regarding this matter within 4 weeks. We request to file a first appeal regarding this matter within 4 weeks and as the demand should be stayed till disposal of first appeal.
Since you are challenging the assessment order, he wants you to challenge You are challenging the assessment order under English Act.
Yes, sir.
in the present rate petition. So stop. Next. Counsel appearing on behalf of the petitioners seeks permission to withdraw the writ petition, the present application with a liberty to seek alternative remedy.
Yes, sir. Lordship, my direction may be given to file this first appeal and within 4 weeks.
We don't know what will you do.
Lordship,
Whether first appeal you will file or otherwise you file, you list this case on,
this,
list this case on
Your Lordship,
Tuesday before appropriate bench within first 5 cases. Chief Justice report. Yes.
Your Lordship, gratefully.
Item number 8.
I'm appearing on behalf of the opposite party.
Well, this is an application for restoration, my lord.
Huh?
This is an application for restoration, my lord.
Item number
Item 8, my lord.
8. Why your application, so this is for default?
Well, this matter was listed for loss on 4/23, my lord. 23. For that, at the previous advert did not appear for which the writ application was dismissed for default.
Dismiss for default, there can be,
Then, my lord, the petitioner, I have stated the grounds, my lord. Petitioners engaged an advocate to appear before this honorable court and
Mr. You could not appear when the matter was taken up.
yes,
लिखो restore. क्या restore करवाएं? 2 तरह एक है this application has been filed for restoration
Obviously noted and
so and so to its original file, comma, which stood dismissed for default in the absence of learned counsel for the petitioner. Considering the averments made in the application and submissions advanced on behalf of the petitioner, this application is allowed. Let so and so be restored to its original file.
Number 68, there is an urgency, your lordship. 1168, your lordship. This is
68 is what?
this is second contempt, your lordship.
Contempt is not urgent.
So, your lordship, the petitioner is a heart patient. So, and he's not getting his provisional salary also. Pension, sorry, your lordship. So, matter is little urgent, can be taken up with your rising.
No contempt is urgent. Yes.
Item 136 and 137, similar matters were lordship has passed in other medical colleges, dropping the contempt and giving the liberty to file a fresh writ because no notice was issued to them. And giving a copy of that order, similar matter was passed, only opposite parties name will be changed. 136 and 137. And another matter, number 528, in view of the lordship's order in the review today, there is nothing remains to be decided in the contempt.
Infectious. 528 instructions.
136 and such similar matter are given now.
Item four. So from this side, yes. Four. Item 448. 448. Yes,
That's item number 15. Order has been complied.
15 compliant,
Realize.
2 minutes, order complied.
32 compliant.
92.
92.
Pardon to mention, my lord.
State matter. This is regarding
Just one.
See, this matter has been listed item number 358.
Any matter? So we withdrawn or
1195.
Quantum matter. So petitioner is any more questions? He have not gotten sufficient allowance. Petitioner is any more question? Lordships, you have not gotten any sufficient allowance till date.
this is
And very difficult to survive, Lordship.
this is contempt application.
Yes, sir. Yes, Lordship. Item number 358.
Give-
Kindly take up today.
Give it,
Yes,
sir.
sir.
No, it's there in the list, below. It's there in the list. Plus, in fact, we have issued letters also. We'll take telephonic instruction, it will automatically come next week. Below. In the meantime, we'll see that it's compliant.
Please wait till Friday. Make a mention on Friday. All right. Next Friday.
Item number 1195, my lord. They have complied and rejected my case, my lord. I may permitted to challenge it in a separate case. 1195.
One.
They have rejected my case. Complied and rejected. I may permitted to challenge that in a separate writ application, my lord.
1195. Not clear. Number.
Lordship, items 1046 and 47, Lordship, it is a contempt matter, Lordship. In this matter, Lordship has passed an order dated 27/9/23 and 8/11/2023 to maintain the status quo order, Lordship. But however, the petitioner has not been allowed to enter the office area, and the salary has also been stopped since January
So
2023.
you are residing in the office area.
Lordship,
Are you residing in the office area?
no, Lordship.
So this is how they have maintained the status quo. Since you are outside the office area, so you cannot enter.
Your Lordship, the status quo order was passed to.
Later,
Lordship.
not.
No, please, your lordship, item 42, my lord, is compliant. For item 42.
Item 45, no instruction.
No, it's-
And also item 105, also no instruction.
My lord, item 43 can be withdrawn.
Item 891, not pressing. 891, not pressing.
Madam, matter not even listed, my lord. It's regarding a paltry sum regarding the pension.
Just this is a contempt matter.
Yes, my lord.
So please wait. All the contempt matters shall be taken up. Please wait for some time. When did you file this contempt application?
I have filed in May, my lord, May 2020.
2024, and the first item is of 2017. All right.
In those days, grateful, my lord.
Item 41, my lord, not pressed. Item 41.
41 not pressed. Please wait. Please wait for some time.
And item 13 complied.
13,
38, sir.
38. Okay.
38.
Item number 9.
Please, your lordships. We had
Yes.
intimated your lordship's intention to the department. Your lordship has given us an instruction.
See the matter that petitioner is retired by Tuesday. Let's say remember that matter, the petitioner is retired by Tuesday. 30th he will retire. He has been served only superannuation notice, but the order was passed to regularize her service. Order has not been complied with. Lots of the 2 times last week also taken on Mukipur.
If they are finding it difficult, they want their appeal to be heard.
My lord, your lordship kindly see, they say that pending writ petition. The writ petition judgment was delivered. There is no pending writ petition, man.
No, writ appeal.
Pending writ.
So they have filed a writ appeal.
After limitation, my lord, just after your content notice, they have filed 9/7, they filed, my lord. Thereafter, your lordship, before that, your lordship directed to comply with your order. After all lordship's instruction, they filed the appeal, my lord. After knowing that, they have.
When was the order passed?
Order passed, my lord, 28/8/2023, my lord. Now going to 1 year, my lord. Thereafter, notice was issued. Writ was issued. They have received the writ of this honorable court. Thereafter, content notice was issued, my lord. They have received the notice. When the order was passed for personal appearance, they complied the order, giving a temporary appointment of some days, my lord, provisionally. That person will to retire by 23rd month. Only 24 days now in service. 5/7 they have given me temporary appointment on the real lordships.
So they have given you temporary.
By retire by 27, by 38, my lord.
You retire, then what? Your services may be regularized.
Well, they have not regularized. Order is passed for regularization because tribunal order is passed 2011. Regularized, my lord, on the basis of 2007. They have not complied. In contempt, this honorable court, they filed an affidavit. This petition is eligible for appointment, my lord. Thereafter, they have not complied, madam. Then I will file again with petition to comply that order, my lord. In that order, judgment was passed, referring to the earlier judgment of the tribunal. That petitioner regrets when her juniors are written in service. So first come, last go basis, he used to regularize for it. I am just reading the operation portion of the judgment, my lord. Therefore, this court has no hesitation in coming to a conclusion that the petitioners are entitled to regularize in view of the Finance Department Regulation number 80. Accordingly, this court directs that the opposite party shall regularize the service to petitioner in terms of regulation. Again, the available vacancies, including posts which are directly falling vacant within a period of 2 months from the date of communication of this order. A copy of judgment be communicated to the opposite by registry by issuing a writ at the cost of the petitioner. So
There are two aspects. This contempt application can be heard along with the writ appeal. But it is their stand that their writ appeals, they are ready to go to jail. They don't say that don't punish them. They are saying that the court may punish them, but at the same time, the court should hear the writ appeal also. So this is the stand which they have taken.
First, they have to file an appeal. Just after
What they have to do, they have decided.
but by limitation, my lord. Your lordship knows once limitation about no appeal is there in eye of law. Your lordship, in another case also hold that when there is no
Now since
there.
all right. Now since they have taken a decision not to comply with the order, till the writ appeal is disposed of, then we have a duty to decide both the contempt application and writ appeal both.
Then you'll also put up on Monday, my lord, in challenging the contempt because this will return by Tuesday.
Anything may happen. The court will decide both the cases. The court will ensure to protect your right.
Yes,
The
sir.
court will not spare them if they have violated.
My right will be protected.
Your right, their conduct, both can be seen together.
My right will be
Just
protected.
in view of the stand which has been taken on behalf of the contemners, list this contempt application along with WA number so and so. So make a mention on Monday that writ appeal. Make a mention. On Monday, make a mention.
My one solution, my right will be protected. Even if I will return, my the benefit of judgment may not be. May not be affected by. So, one line will also my.
This is contempt application.
Yes,
no?
my lord.
They say that they will not implement. They say that they will not implement because writ appeal is pending. All right. So they have decided not to implement.
Item number 1. In item 1, I am filing the complaints affidavit. And also,
I've gone through that, my lord, it's not this, they've complied.
they have paid it since 2019.
I have said that complied.
My director is in BC, my lord.
Yes. Director. Dispensed. Was it directed to be present?
Yes, you'll also direct because on that last.
It is an admitted position that this court's order violation of which has been alleged in the present contempt application has been complied with. Contempt proceeding stands stopped accordingly. Stop. The director.
Higher education.
Higher education. The director higher education has joined the court proceedings online pursuant to this court's direction. Stop. His personal his appearance stands dispensed with. The contempt proceeding is dropped. Yeah. Yes.
Item number 2. Item 2, my lord, in this case, my lord.
Item 2, my lord, we have filed last problem, my lord, kindly see, we have filed SLP. This is the SLP number. And the director is present before my lord in this.
Yes. SLP is actually nothing can be. It is the stand of the stand taken on behalf of the contemners that an SLP has been preferred against the order passed by this court in writ appeal.
Writ appeal is writ appeal or distance.
WA number.
Writ appeal 1609.
1609
2022.
Of 2022.
This is 13/11/2023.
Whereby the order passed by this court in WPC bracketed OAC number 623 of 2018 was affirmed. Stop. The petitioner has alleged disobedience of this court's order dated
9/12/2021.
9/12/2021 passed in WPC OAC number 623 of 2000.
Yes, 18.
So, since the contemners have approached the Supreme Court, in the court's opinion, no case of deliberate disobedience of this court's order is made out. Of the contempt proceeding stands stopped accordingly. Yes.
Personal appearance, my country.
Personal appearance of the director, elementary education.
Number 3.
Elementary education also joined on
Order dated
2021. Which case?
Item 3, my lord.
Yeah.
Offices, Secretary Health and
family welfare.
Yes. Complied with or not?
Not yet, my lord.
Because he is an employee of the SCB Medical College and Hospital, who are the reporting authority. There was a direction to the state government to consider his case. And his representation was disposed of since 2021 with the intimation he should approach the medical authorities along with the press application. Because they are the appointing authority.
My lord, order your loss of kind of glance. Just now you serving a copy as just now serving a copy. The order is very clear, my lord. Loss of case 12. Para 10, my lord. Operative part is, my lord, para 11. Phase 12, planning phase. In that view of the matter, my lord, my place, my lord.
So who is respondent number one?
My lord, this Secretary Health and Family Welfare, my lord.
So whether the secretary had the jurisdiction.
My lord, you have just rejected my case, my lord. Secretary has rejected, my lord. My case was rejected by the secretary, which was again challenged before this honorable court in WPC number so and so. Thereafter, this order, this honorable court has final verdict has come in 29/10/2021, and the order has been set aside, my lord. Again, direction was given. So, question of representation, consideration of representation doesn't arise here, my lord. As per the order clear, my lord. So again, they are coming with a letter, my lord. This is 23/10/2021. Since last contempt is pending, my lord. The several orders have been passed. They have serving just now a copy to which is 23/12/2021. Kind of a glance.
According to you, this is the case of backdating.
My lord, your losses for a moment.
Yes.
11/8/2023 order. For a moment, to this contempt, my lord. This honorable court director last chance 2 weeks time is allowed to come to implement the order of this court. Failing with the contempt shall appear before this court and explain as to what is the order.
What is the order?
Order we have to come to give appointment.
No, what is the order which they have passed?
They have just not given a copy. I have not gone through the symbol.
Go through that.
Model.
It has been communicated.
Let it be next
to
week.
petitioner by the speed post also in 2021.
Where is it? Where is?
Where is
You have not given a affidavit also.
It is stated on behalf of the contemners that
Next week.
in the light of this court order dated 29/10/2021, the petitioner's case was considered. 21 passed in WPC number 1259 of 2018. The petitioner's case was considered and an order was passed on when 23/12/2021 itself, with intimation to the petitioner. Learned counsel for the petitioner states that he does not have any instructions from the petitioner in this regard. First off, what do you want?
I'll file a reply, my lord. They are not yet given a copy, my lord. And for that, for a moment to page 13. After this, my lord,
Mr. Counsel,
I'll file and reply to the same, my lord.
who could have taken decision in your case? You were the employee, the deceased employee was employee of which department?
SCB Medical College, my lord.
SCB Medical College.
My lord.
Who is the appointing authority?
The SCB Medical Authority is the appointing authority.
Who is respondent number one?
Respondent number is the secretary, my lord.
Secretary is SCB Medical College.
What happened, my lord, in this case?
What happened? You could have filed an application for modification that the order ought to have been issued to some authority of the SCB Medical College. Respondent number one cannot do anything.
My lord, what happened in this case, my lord? SCB Medical College Authority Superintendent, my lord, they have forwarded my representation
with all other smaller.
File.
That is what they have written. I'll file a reply, my lord.
Yeah, look. From the petitioner in this regard, most of he seeks adjournment to obtain instruction and respond to the stand which has been taken on behalf of the contemners. File an affidavit. Is this matter on 4 weeks?
Item number 4, advertisement.
May I please, your lords? They have come yesterday to attend his office for signature in the pension papers, but they have not yet paid anything, my lord.
Yes.
But at item 4, the last order passed on 5/7/2024.
Yes.
The additional chief secretary appeared on behalf of the Water Resource Department and assured this court that there will be a compliance of the direction of the honorable court. Thereafter, the calculation sheet and everything was processed. And in the meantime, the petitioner has been asked to submit the pension papers. So that is a process. It will take just 10 to 15 days. The order will be fully.
Do it, do it.
Fine.
I will not dispose it off.
Your lordship may keep it pending.
Keep it pending. This matter on at the request made by AGA representing the contemners. List this matter on 4 weeks. Or stop. He has submitted that steps are being taken to ensure that the petitioner is paid his post-retirement dues.
Well, my lord, the original petitioner, he is dead. Now the wife is to get the pensionary benefits.
Pensionary benefits.
Along with family pension.
Pensionary benefits.
Yes, that is.
Yes.
Item number 5.
My lords have kept it to
4 weeks.
4 weeks. Obliged.
Item number 5.
In the meanwhile, this is short.
My lord.
Item number 5, your last occasion I filed a affidavit stating that we are going to approach the Honorable Supreme Court to file it. Now I filed a focus affidavit yesterday stating that we have already approached the Honorable Supreme Court in SLP not given the guide number. The writ appeal was dismissed on the ground of denied license law. There was a direction by the Honorable Single Judge to regularize the services of the petitioner who was an employee or something like that, and again that writ appeal was not preferred and appeal was dismissed only on the ground of delaying filing that appeal. In many cases, the Honorable Supreme Court says from this Honorable Court only, notice has been issued in the position of limitation.
Where is the other person?
The other person is also here.
My lord.
Retired. So
He's retired in the meantime, so I'm appearing for him, my lord. He has retired in the meantime. I'm filing a show cause.
I am taking both of them into custody.
one thing,
My lord, what has happened is in my case, if my lord may kindly permit me to submit. My lord, yes, my lord, I'm filing the show cause. My lord, here what has happened?
Have you served the copy?
No, my lord. My lord, I'm serving it right now.
Serve on him.
My lord. Yesterday, my lord, I only received the notice for personal appearance, my lord. 25/7, my lord.
one indulgence first, even though we have not preferred
The whole, Mr. Counsel, the difficulty is that you file a so cause which is not there on the court. It is difficult for the court to pass any order. Today, he is filing a so cause. The copy has not been served upon him. He has the right to go through the so called reply.
Even though we have to the Supreme Court, people also give a word saying that we will comply the order subject to SLP final result.
You do whatever you want.
Why is it only the losses?
You do, see,
Mention that because the appeal should say that orders will comply. So only one line from the lordship's mouth that the order will be complied subject to SLP.
why should I? Why should I? I will not say anything. You do whatever. The court will just see your intentions. Your intentions are clear. You have decided not to implement the order. Your writ appeal was dismissed. You did not prefer SLP. You decided not to implement the order. The court is not that weak.
No,
Yes.
I'm not saying that. I'm not saying that.
Give him a copy of the so-called, I will not see your so-called reply. Liko? The,
Malad, I'm serving it.
Mr. So and so are present in court. दोनों का लिखा देना. Give your description of the court. Is of the court reiterates its prima facie opinion that this court's order has been intentionally violated by the contemners. So stop. So-called, you add him as a party, whether he is a party or not.
Malad, he was not a party.
Directed to adding as a party. It was directed to adding as a party.
He has been added.
No, no.
Add him as a party.
Consolidated title, cost title, madam. Consolidated cost title, madam. Adding one party.
So-called reply. He is respond number?
This one have not been included as a party yet.
No, he have been implemented.
My lord, we have filed a consolidated cost title, madam.
Related cost title is there.
No, I have not received, my lord. I have not received that.
Then don't file.
My lord had directed because my lord order was there, so I filed, my lord, in the regards to that order. My lord, if my lord may give me a moment, I'll explain the chronological timeline, why he is not involved, my lord.
Not now. क्या लिखा? By the contemners. The Mr. So and so, what is your name? Narayan so and so. The present position, what is his? Chief engineer. Chief. And his predecessor. What is your name? Are present personally in court in compliance of this court's order, previous order. Top-learned counsel for the petitioner has stated that a phrase cost title has been filed in the registry by adding next as a party. No stop. Learned counsel representing retired submits that he intends to file a so-called reply in defense. So stop. Let a copy of the said so-called reply be served upon learned counsel for the petitioner in course of the day. So stop. List this matter on 2 weeks. On the said date, both so and so shall be required to be personally present in court. Yes.
Item number 6. Pardon, my lord. Pramod Kumar Naik, retired EIC, my lord. Pramod Kumar Naik, retired EIC.
Predecessor, he was predecessor. Retired is the contempt is against an individual.
My lord.
Either he is retired or not retired, that is immaterial.
But item 6. Item 6 matters that university matter. I filed a compliance affidavit yesterday in one case matters. In another case, contempt number 3561/2023. I'm filing it today itself. My humble contention that we have complied, whatever the order we have complied.
No, your lordship. I'm
My lord, kindly have a glance.
I'm giving a copy to my learned friend.
Item 6.
My lordship.
Let me see the order.
My lord, my first half content 3561 of 23.
What is the order of this court?
Page 20, para 9. It starts. May I read, your lordship?
Just a minute. Page 20.
Your lordship, 3561. 68.
35? 3560.
Your lordship, 3561.
Yes.
Para 9. It is in this view of the matter, this court finds the show cause notice is when person not maintainable. As a consequence, while declaring the show cause notice by annexure 1 remains bad in law, this court observes as per the view already taken on the manner the report is prepared, the report involved here is not sustainable in the eyes of law. This court finds while entertaining the writ petition.
You are reading which page?
My lord, page 2. I started from page 20, para 9.
Yes.
May I read once again?
Yes.
Para 9. It is in this view of the matter. My lord has that.
Yes.
This court finds the show cause notice is even person not maintainable. As a consequence, while declaring the show cause notice by annexure 1 remains bad in law, this court observes as per the view already taken on the manner the report is prepared, the report involved here is also not sustainable in the eyes of law. This court finds while entertaining the writ petition by order dated 18/10/2000, this court had already directed that the disciplinary proceeding initiated against the petitioner may continue, but there shall be no final decision, which order is in operation as of now. In this circumstance, this court, while setting aside the show cause at annexure 1 and the inquiry report enclosed, allows the writ petition. It is at this stage, considering that the proceeding was initiated in the year 2000 and the petitioner was aged about 46 years old in the year 2000, having attained the age of superannuation since long, and there is no possibility in continuing with such inquiry. There is also no possibility of punishment, considering that the petitioner is already attained the age of superannuation. In this circumstance, while setting aside the show cause notice, wide annexure 1, and declaring the inquiry report as bad in the eyes of law, this court directs the Utkal University to consider the case of the petitioner for retirement benefit. Benefit of the petitioner on superannuation, if not cleared, be calculated and paid in favor of the petitioner by undertaking the entire exercise within a period of 1.5 months from the date of communication of an authenticated copy of this order. The petitioner will also be entitled to interest at the rate of 5% per annum all through. My lord. My lord, so what I submit is now, my lord, you'll also may kindly see the conduct of the content.
What has not been paid?
My lord, I have not been given my arrears salary as I would have been entitled to.
Is there any direction for payment of arrears salary?
My lord, benefit of the petitioner on superannuation.
All right.
So
superannuation is not arrears of salary, is not benefit on superannuation. All right. What else?
Yes, my lord, my gratuity has been calculated at a wrong amount.
That cannot be gone into in a contempt proceeding.
My lord, the gratuity, my lord, that there's, my lord, on the records, my lord, that there's.
Mr. Counsel, we will go, the court will go by the order which has been passed, not otherwise.
Your lordship.
What else?
My lord, I'm not been granted pension, your lordship.
Pension you have not been given?
No, my lord.
Pension, my lord, not entitled to.
Not entitled to.
My lord, that is the submission, but my lord, I would respect.
That you can challenge. You can.
So for my lord's area salary, we have released that amount to, because of the observation, release that salary, area salary amount, my lords, 31 lakhs. Some all my lords we have already released, deducting my lords the that income tax deduction, 21 lakhs we have already accounted for in each account, including EOMs that unutilized leave period 300 days. That also we released.
My lord, may I respectfully submit that the amount that the state to have been released.
Mr. Counsel, had there been any direction that you were required to pay this much of amount, or you were required to pay gratuity, or you were required to be paid pension, the matter would have been different.
My lord, the retirement benefit in its entirety, my lord.
Retirement benefit we don't know. But there is no direction that you should be paid pension.
My lord, then lordship may kindly give me next week.
No.
My lord, I'll file a judgment. Retirement benefits include pension, gratuity and otherwise.
Sorry. Have you filed your so-called?
Yes, madam.
The petitioner has alleged disobedience of this court's order dated
My lord, may I pray for leave to challenge also.
21 passed by this court. Sorry. Court in OJC number 10148 of 2000. Operative portion of which reads as under. Stop. A so-called reply has been filed
18/7/2020.
behalf of the contenders, wherein specific stand has been taken that the said order has since been complied with, and the petitioner has been paid the arrears of salary consequent upon washing of the so-called notice and the disciplinary proceeding. Full stop. It has also been stated that salary equivalent to unutilized earned leave has also been paid to her. The payments have been made after deducting TDS.
Income tax matters, 9,83,000.
TDS.
9,83,145.
TDS. So, Land Counsel for the petitioner has submitted that the petitioner has not been paid gratuity and pension.
Gratuity, area salary as would be rightly payable, and the pension.
Gratuity and pension. So, he has also submitted that the areas of salary have also not been duly calculated.
Your Lordship.
Stop.
My humble contention, gratuity has been paid, while CPF has been paid, pension is not entitled.
Stop. In such, considering the stand taken on behalf of the contemners and the nature of order passed by this court, violation of which has been alleged in the present contempt application, in my opinion, no case of deliberate disobedience of this court's order is made out. So, the contempt proceeding is accordingly dropped. So, next, it goes without saying that the petitioner shall be at liberty to raise his grievance in relation to calculation of areas of salary, etc., and entitlement of pension before appropriate authority in accordance with law. Appropriate authority / forum in accordance with law.
Item number 7. Gratefully, Lordship.
7 non-complex.
Before submitting the, I am putting some words. My lord, last direction, I am in virtual mode, my lord. Excuse my lord.
Yes.
My lord, last occasion, my lord directed to comply the order, otherwise the concerned official will pay. After that, we have calculated the same, entire amount has been paid. But one mistake is there in our part also enlightened the court that in the time of disposal of the writ appeal, instead of 2010, it was written 2017. So even though he has superintended in 2010, in that respect, to file a IA is pending. My lord may keep it to some other day. In that meanwhile, I will file a detailed affidavit as about the compliance of the order of the High Court, as well as how much amount has been paid and entitled to. So let's say keep 10 days. Then in the meanwhile, we'll file this.
Is it correct? And there is typographical error.
Now that he's submitting that some amount has been paid, I have no instruction. I'll take instruction. Let them serve me a copy of the affidavit. I'll take instruction.
We will not file affidavit. We will prepare the affidavit, file within 10 days.
Yes.
Just now received the instruction from my learned friend is there in the court is.
Yes. Next.
Item 8. And that is my lord. The order, 21/11/19, where the compliance affidavit has been filed yesterday, I'm serving a copy. But the authorization has been sent to the principal office of Principal Accountant General for release of the pensionary benefit. And just now I received the information, the PPO has been issued and the district treasury has been directed by the
Yes.
Principal Accountant General. There is direction for payable interest of 18%. That not been paid. Then direction for pay the pension along interest around. And you should pay 16 para 10. Interest rate is there for 6 years. I have returned from 18 madam, 24. I directed to pay the release the pension along with paying the interest there, 18 interest. That has not been paid till then, madam. So there is a not compliance, madam. Kindly
Yes.
pay 16.
18%.
Paragraph 10, para 10. Correct. No direction.
Pay 18%.
Mother, 18% they have not, regarding that 18% they have not reflected in the show cause affidavit. The lordship may keep it
So
to whether it has been, the pension papers have been covered. Yes,
file first.
yes.
It appears from the submission advanced on behalf of the contemners that though the pension payment order has been issued by the office of the Accountant General, the direction, this court's direction to sanction pensionary benefits
With 18%.
with interest at the rate of 18% per annum has not been complied with. To stop. List this matter on 4 weeks. Stop. The court will consider initiation of contempt proceeding against the contemners if in the meanwhile this court's order is not fully complied with.
Well. Your lordship may also indicate that they will file a fresh affidavit indicating that.
Don't file.
Well,
Don't file today.
Old matter item number 10.
On appears.
Item number 11.
Mr. Ratha is ill. My lord, Mr. Ratha is ill. So it may adjourn next week.
What is the order? All right, as requested, this case on. As requested on behalf of the petitioner, that's this matter on. Yes.
Item 12. Item 13.
On appears.
Item 14.
Sir.
Number 1.
Microphone.
Number 1 is over.
Present president, Lord, I have
Petitioner. And for the petition. And it is, this is the second contempt election. And in the writ application, there is given to 6 months time to 6 months time to communicate the order. But
Yes, whether the order has been complied with or not.
no, ma'am, order not. Term of appeal number 1 is over. Petitioner has to impute the present president as party member. Will file shows within a week.
So the appeal was directed to be disposed of. Appeal has not been disposed of. Who was required to dispose of? Who was required to dispose of the appeal? KCC Bank. What is KCC Bank?
Koraput Central Cooperative.
Koraput Central Cooperative Bank.
Oraput Central Bank was noticed.
Yes.
And the order was passed. No.
Yes.
No. The order was passed on the very first day. No contempt. The petitioner has alleged disobedience of this court's order dated 24/11/2015, passed in WPC number 20205 of 2015, whereby the petitioner's appeal was directed to be disposed of. From the records, it appears that the Secretary KCC Bank, Head Office Jaipur, District Koraput, was required to consider the petitioner's appeal. Stop. No notice. The said order was passed without any notice to the president or the secretary of KCC Bank Limited. Stop. In such view of the matter, in my opinion, no case of deliberate disobedience of this court's order is made out. Contempt proceeding is dropped. Yes, next.
Item 16.
Contempt matters will not. These are 2019 matters.
Some problem, he requested me to take the Passover.
Please see what is the order. Yes, what is your instruction?
No. Until he has not filed it, I don't know, there was a direction to not ensure you have disposed of the enforcement case. I'll find out now, so we are only.
As requested on behalf of the petitioner, list this matter on 1 week. Stop. In the meanwhile, London AGA will be required to seek instructions as regards compliance of this court's order, violation of which has been alleged in the present contempt application. Yes, next.
Item 17.
Lords. On complaints of order dated 21/10/2019 in Pageant WPC number 643/19.
Where is the order?
That's the order I put it in para 4, Lords. In last question, page number 4, no construction work on plot number 167 under khata number so and so in Mauja not shall be taken up till disposal of the appropriate representation of the petitioner by the collector.
Where is your representation?
Representation in read petition annexed 4, let's see. Annexed 4 is the representation, let's see.
What is the date?
Date was 19/12/2018.
What is the date of your representation?
Let's see, date was
So, without not wasting time, order has been compared with lands have been settled with them, record of RR, the right has been issued in their favor. I will
have any instruction?
Counsel
for the petitioner does not have any instructions from his client. It has been stated by learned AGA that this court's order, violation of which has been alleged in the present contempt application, has been fully complied with. In such view of the matter, Contempt proceeding stands dropped. Yes,
Item 18. My lordships, the order has not been complied till late, my lords. This is a third contempt, my lords. And the petition requires filed on 11th March 2013, my lords. 19
orders. Where is the first order?
Third, my lords, WBC number 8895 disposed on 29th April 2013.
So you may see this order was filed passed to consider representation without expressing any opinion. Whether any representation has been considered.
To consider his papers were submitted to the your Accountant General AND. That was my instruction long back. It will also grant time I can option for this instruction. We are the 2018 on 18/1/2018, the original service book records and the family pension papers were submitted to the Accountant General. So as back as in 18. So what is there some of I'll often instruction.
Do you have any instructions?
No, my lords.
Then why are you pressing?
Not complied too late, my lords.
This is your instruction.
Yes, my lord.
2 weeks time is allowed for the contemners to inform this court as regards compliance of this court's order dated 29/4/2013, passed in WPC number 8895 of 2013.
Item 19. 19 has been complied with me also.
Complied.
Item 20. 20 also complied with me.
Complied with.
21.
My lord, it has not been complied in its true spirit. Your lordships may kindly see order dated 23/2018, my lord. That is at rolling page 8, my lord. My place, my lord, para 3, my lord. Taking into consideration the facts and submissions and without going into the merit of the case, the writ petition is disposed of directing the BDO Jharkhand opposite party number 6 to dispose of the representation of the petitioner by Annex of 5 within 3 months from the date of receipt of a certified copy of the stock. And to see that page 8, ma'am. Page 8. Rolling page 8.
This is
Item 20. Item 20.
Contempt 188. Got it, my lord?
yes.
Yes, in the middle person. And to see that the private land of the petitioner is not encroached at the behest of any other person. What has happened, my lord? The petitioner has got some right to land, my lord. Over that, one Pradhan Mantri Awas Yojana has been sanctioned in favor of another person.
Mr. Counsel, this order cannot be implemented by anyone. If a direction is issued to the authorities to ensure that your land is not encroached by any other person, this order cannot be implemented. So if an order cannot be implemented, then there is no question of violation of the order. Representation, yes.
In my place, another person's house has been constructed by the
See, if I issue a direction that your client should not be beaten up by any person outside the court or anywhere, whether that order can be implemented?
No.
Then the petitioner alleges disobedience of this court order dated 23/2018, passed in WPC number 2808 of 2018, operative portion of which reads as under. As taking into consideration. So, the petitioner's representation has been disposed of. Also, counsel for the petitioner, however, states that the opposite part, that the contemners have failed to ensure that the petitioner's private land is encroached upon at the behest of any other person. Also, the said direction of this court. I am not inclined to initiate to proceed with the present contempt matter for violation of the nature of direction as noted above, which was as since the order was passed on the very first day when the matter was taken up on 23/2018 after filing of the writ petition. Yes.
21. Order has already complied.
Complied with.
From 22.
22 lawsuit is infectious lawsuit.
Withdrawn.
Infectious.
Instruction.
Item number 23.
On appears.
23 complied with.
Complied with. No one appears on behalf of the petitioner. And it states
24 also complied with.
same order.
Item 26.
He states that the order has been complied with. 26, no one appears.
Item 27.
Same order.
28.
Same order.
Item 29.
Near to the lordship.
Yes.
The petitioner filed a revision before the member of board of the.
Where is the order? Where is the order?
Yes. I have quoted the order. Order 26, initial order 26/7/2018. And quoted para 3.
Yes.
It has 3 of the contribution.
Just a minute.
Next week I can open.
As requested on behalf of the contemners, place this matter on 1 week.
Item 30.
No one appears.
31.
And no instruction. No instructions.
Item 32.
No one appears.
33.
No one appears.
Item number 34.
Item 32 to 36.
All complied.
Complied my lord, but copy has not been sought, my lord.
32 to 36 complied with.
Item 37.
In several lordships, as per the contender lordships, I have already complied the so called 5 lords.
Complied with.
Item number 39.
Order has been complied.
Complied with.
Item 40.
No one appears.
Item
Order has not been complied till date. I will- 40.
Item 40.
Your lordship may praying for time for 1 week to file reply of complaint.
No, what is the order? Let us see.
Order dated 1st May 2018. Your lordship.
Where is that?
This is the second contempt, your lordship.
Madam, there is no order. What is the order? Let us come to the order. On the very first day, the writ application was disposed of with the direction that if you make a request involving demarcation pending, then Tahsildar will direct you to take a decision.
And it has been done, so I filed the compliance affidavit.
But there is filed a false affidavit for that reason. I have filed the reply of that complaint affidavit.
Huh?
For that reason, I have filed a reply affidavit of the against the complaint.
That statement is false.
Yes. I have all the
Even if that
evidence.
statement, even if that statement is false, there is absolutely no order which is required to be complied with.
Your Lordship, order dated first May 2018 has not complied till date, Your Lordship.
See what is the order. Please see what is the order.
Just
Was any notice issued before the order was passed? Whether the opposite parties were noticed before the order was passed. Then what kind of order? You are saying implementation of the order.
first contempt would have filed.
First contempt, where is the question of first contempt? Where is the second contempt? If there is nothing in the original order. Passed without even notice.
Opposite party has been appeared and filed the counter, Your Lordship.
In this case.
Your Lordship.
Very good.
Read petition.
Madam, you are appearing 501 of 2019.
Your Lordship.
501 of 2019.
Your Lordship.
Counter affidavit was filed. But counter affidavit has not been discussed. And with the second order. Madam, your writ petition was disposed of on the very first day.
Your Lordship.
On the very first day when the matter was taken up.
Your Lordship.
Where is the question of filing of counter affidavit?
Counter affidavit, pardon, Your Lordship. On the same day, dispose of the writ petition with the direction to the opposite party for.
Therefore, the court is saying that order could not have been passed. No direction could have been passed without notice.
Opposite party is a Tahsildar Bhubaneswar, and the second contempt he was appeared and filed counter affidavit, Your Lordship.
In the second contempt was unnecessary. First contempt was also unnecessary.
Because of that, he has not complied the Honorable High Court order, Your Lordship.
Who are you?
And the petitioner.
Oh. No, I am not.
That is Suka's
I am not. The petitioner in the present contempt application has alleged disobedience of this court's order dated 1/5/2018, passed in WPC number 7244 of 2018, which reads and under. Compliance affidavit has been filed, stating therein that the court's order has been complied with. The counsel appearing on behalf of the petitioner has submitted that the stand which has taken by on behalf of the contemners in the compliance affidavit is false. Next, be that as it may, it is evident from the records that the said order dated 1/5/2018 was passed on the very first day when the case was taken up without noticing the opposite parties in the writ petition. In such view of the matter, I am not inclined to proceed any further in the present contempt matter. This contempt proceeding is disposed of accordingly, dropped accordingly.
Item number 44. This is out of interval, along with petition of kind.
Entry order. This contempt petition along with WPC number. Before
Number, my lord, 4743.
Before the assigned bench.
Item 45, now same, my lord. 46.
No appears.
47.
Same order.
Item 48.
Same order.
Item 49.
Already complied, my lord.
Complied with.
I am for opposite party number one. I am for the petitioner.
Complied with.
Item 50,
50, my lord, already complied.
Complied with.
51.
51, my lord, SLP is pending, my lord.
SLP.
My lord.
SLP is pending.
My lord, SLP is pending, lord. In the meantime, lord, they have also noticed for local adalat. The petitioner has also noticed for local adalat, lord. So let's say, what my subject, lord, let it be pending, lord, till the disposal.
No,
SLP is pending.
as on date, there is no disobedience.
Lord,
You'll have.
well, last 5 years that SLP is pending.
What can be done?
The only.
It is not their intention to disobey. Rather, they wanted to challenge the order.
And the also grant liberty that after disposal,
As the order of this court, violation of which has been alleged in the present contempt application, has been assailed before the Supreme Court by filing SLP, which is pending, in my opinion, no case of deliberate disobedience of this court's order is made out. The contempt proceeding stands stopped accordingly. So it goes without saying that the petitioners will be at liberty to take recourse to appropriate provision of law subject to outcome of the case pending before the Supreme Court.
item number 52.
52 may I please? 52 order dated 4/5/2018 has not been complied with. My lord, page annexure 1, page 6, page 8 is the relevant. Page 8. Wherein was directed to consider the representation of the petitioner.
Annexure?
Annexure 1, my lords.
Yes.
Page 9, my lords.
So what is the direction?
My lord, the direction was considering the submission, my lord.
Direction to dispose the representation, my lord, let's kindly grant some time so that I will file it.
This order was passed in 2018.
My lords.
I'll take this.
And this contempt petition is pending since 2019.
No, grant the last chance, my lord, so that I will. That must be disposed of.
Matter on. So this is what you are doing despite the repeated observations made by this court.
My lord, grant some time, my lord, so that that must be disposed of.
By way of last indulgence, by way of indulgence, the matter is adjourned to next Friday for an AGA to seek instructions as regards compliance of this court's order dated 4/5/2018, passed in WPC number 7285 of 2018.
My. Obligement. Item 53. 53, my lord, SLP is pending, my lord.
SLP is pending, my lord.
SLP. Yes.
Item 54.
Yes,
54.
No.
Item 55. Already complied by.
Complied with.
56.
Non appears.
Item 57.
This matters, this honorable court has directed the opposite party number 1, Collector Jajpur, to consider the representation of the present petitioner matters. By the order dated 38 of 2017 matters, but till date the same has not been considered.
My lord, that was considered, my lord, my lord. Annexure B.
Annexure?
Annexure B of his local reply, my lord.
Yes, 5, my lord.
The from the so-called, yes, that
But
has been
the copy has not been served. I'll serve a copy, but so
so you can challenge that.
my lord. If you serve me a copy, my lord, so-
You can, I'm disposing it off.
my lord.
The petitioner has alleged disobedience of this court's order dated 30/8/2017, passed in WPC number 14809 of 2017, whereby the petitioner's representation was directed to be disposed of by opposite party number one, by the collector Jajpur. First off, a so-called reply has been filed on behalf of reply has been filed in this case, stating therein that petitioner's representation has been disposed of and his claim has been rejected.
My lord.
First off, by order dated,
By order dated 16/9/2018, my lord.
by an order dated
Item 59.
nine one refused.
Item number 60. 60, my lord, the order has been complied with.
No, not complied, Lord. So, Lordship, can you see? This honorable court specifically, page 6, Lordship, can you see? Paragraph 8. Contempt proceeding is disposed of, directing that if the direction issued by this court in the aforesaid order, it shall be construed to be contempt of this court, or moving this court in a fresh contempt petition, contempt shall be punished under Contempt of Court Act. Specific direction. Lord, earlier to that, your lordship directed, your first order is writ petition C number 8320 of 2006. The specific direction was, since it was.
You are reading from what?
Lords, the earlier writ application where the orders passed by this court.
That you have not annexed.
That was earlier petition that must have called for, because this is contempt matter. Plus, connected to that earlier writ application that could have been tagged in laws. There lordship specifically directed a calculator and a pay. Otherwise, this will be construed to be contempt laws. Plus, till that they have not released the same nor calculated. Rather, they have filed a counter affidavit or so called saying that the earlier they have rejected the case of somebody, on the basis of that they are rejecting my case.
Your writ petition is not here.
Lordship,
You have not annexed the order.
Lordship, order.
And there are three CMAPL. CMAPL means restoration.
Restored.
And this contempt petition is pending since 2010.
Yes, Lord.
And it is because of you that the contempt petition is pending.
No, not because of me, Lord.
Then?
Lord, so the matter was not being listed.
Why these CMAPL?
Lord,
CMAPL, three CMAPL.
restoration, Lord. Dismissed for default.
So I will not proceed after 15 years in contempt jurisdiction. The petitioner has.
Poor petitioner will suffer, Lord.
Poor petitioner, you have made the poor
No, I am not at fault. Lord, the registry is at fault. Because registry, Lord, the mistake of the registry matter could not be listed, and because of a lordship's kind interference, matter is being taken up and listed.
No, what about the CMAPL?
CMPL, that has already been allowed and the rest file is restored.
Therefore, court is.
Once your lordship allowed my application and the matter is restored to the original.
Whether the court has a right to decide your case on merits.
No, at this stage I will not pursue lordship to hear on merit, because this is the specific direction they will lordship that they have. If they will not comply the order, that will constitute to a contempt.
All right. The petitioner in the present contempt application has alleged disobedience of this court's order dated 17/4/2007. What is the order?
Order is dated, first order is dated, my lord. 28/6/99, division bench order.
28/6/1999. Passed in
Passed in OJC number 3321 of 98.
and
And next is writ petition C number 8320/2006, order dated 17/4/2007.
7. So the present writ petition was filed. Present contempt application was filed in 2010. Stop. The order sheet indicates that the contempt petition was dismissed for default, price, and subsequently restored. Stop. As the allegation of disobedience of this court's order relates to the orders passed in 2009, है ना? 2009 and
26/99.
and
Second one is 17/4/2007.
2007. I am not inclined to proceed in the present matter on the ground of delay. Stop. The contempt proceeding is accordingly dropped. Yes.
Item 61.
Not
61 will comply with matter, sir.
Not to confirm my lord, I have not. My lord, I not, in it two couple of occasions, the state council take time to comply and to pay the payment, my lord. The order, operation of the order, my lord, the GPF deduction.
It was already deducted, my lord. Can you see the last page of that?
That's all.
It's already deducted 11,000
The
something.
allegation, agency has not received any amount till now. Even if yesterday my client contacted me in the overphone that I have not received any money.
But yes,
Let's have some, that matter already been deducted, my lord.
what has been done?
You can see the last page, my lord. GPF slip, my lord.
Come to the order.
My lord.
But the simple grievance of the petitioner who is working as a Hindi teacher is
Simple grievance of the petitioner, Mr. Counsel, the order was passed in 2004.
Yeah.
You filed the contempt petition in 2007. We are in 2024. Why the court should entertain such contempt application?
Previously also I draw my lord's attention.
Previously,
In another contempt matter, CONTC 323 of 2005, it is a disposal with the direction of 2/12/2008. Thereafter 2010 contempt is before my lordship. And it is also direction. Back to my annex of 2, my lord.
please come to the order.
My lord. Let's see, can you see the last page of the, I have entered the GPF slip, my lord.
Mister, please come to the
My
order.
lord, my lord.
Order is there. In view of the fact and circumstances, I dispose of the petition directing the district administrator school opposite plan number 3 to deposit
So
the.
this has been done.
My lord, already deposited and that has been reflected in GPF sheet, my lord.
And receipt.
A compliance affidavit has been filed on behalf of the state, on behalf of the contemners, stating therein that in compliance of this court's order, violation of which has been alleged in the present contempt application, the amount deducted from the salary of the petitioner has been deposited in the provident fund account, which was required to be deposited in said account. So, in such view of the matters, in the court's opinion, this court's orders having been complied with, the contempt proceeding deserves to be dropped. Contempt proceeding The contempt proceeding is dropped accordingly.
Item 62.
Yes,
62, my lord, I have already complied there.
complied with.
Up to the compliance report.
Complied.
63. Yes, 62. My lord, in this matter, the complied with me. Complied.
Complied.
Please give the complaint. Item 64. Thank you.
64, my lord. There's a writ appeal, because number 2 of 2015, that was filed challenging the order to learn single judge. But that writ appeal was dismissed for non-prosecution, for which the restoration application is pending. So I pray that this writ appeal may be listed in the next time. But as I can, order of the earlier sanction was not appearing in neither the contempt or the writ appeal. That was why it was dismissed. It also was not received the restoration application. So my lord, I filed my wakalat on my day before. I have received all the records, but certain records are missing. So let it be listed along with the writ appeal manuscripts after I go through all the.
No, it will not be listed along with the writ appeal.
The writ appeal, my lord, says that it was of 2015.
Maybe
26 September 2022.
My lord, restoration application, my lord, is CMFDL number 647 of 2022. That is pending. 22.
why don't you make a mention for restoration?
No, right. Because I filed the day before because of my lord's order. The earlier council had informed that they have been dependent and will not appeal.
As requested on behalf of the contemners, this matter on 4 weeks. It will come after 4 weeks.
65.
Item number 65. But Rosti may kindly come to the order part that is on page 9. The order cannot be executed by the present contemners. You can also kindly come to page 9. Non-appears for the petitions when the matter is called. The writ petition has been filed by the petitioner for issuance of no due certificate in their favor against the loan taken by them from the opposite party.
65.
1161.
Yes, sir.
Page 9.
Page 9, the order of not so passed by this one.
Page 9 is not there itself.
There was contempt application.
What is the order?
The order is being read out here.
Yes.
None appears for the petitions when the matter is taken up. The writ petition has been filed by the petitioner for issuance of no due certificate in their favor against the loan taken by them from the opposite party financial institution.
Which is the financial institution?
Which is in the bank, the rural housing corporation bank is a financial organization. And the controller is the employer of them, it's a coil corporation. Coil corporation of Odisha. Coil corporation of Odisha. Yes, employees, they filed the writ application stating that they have taken a loan from this bank, and the bank is not issuing them the no due certificate. And this also directed the corporation to issue the no due certificate.
In fact, the petitioners are the employees under the contempt office matter. And the amount installment has been deducted from
Just might have been deducted, but who was required to give no objection, no due certificate? No due certificate. No due certificate, Mr. Sawan. Who was required to give?
No, bank has given the no due certificate, but the petitioners are employed under the contempt office. And the amount has been deducted from the salary of the company from contempt office matter. That has been deposited with the bank.
That has not been, what is the direction?
Direction to dispose of our representation by the contempt within stipulated period matter. That has not even complied.
That is very difficult. Consider representation disposal. I find substance in the submission advanced on behalf of the contender that the direction issued by this court to issue no due certificate.
No due certificate.
Certificate to in favor of the petitioner by the choir board. What is
Orissa Cooperative Choir Corporation. Orissa
would not be
Cooperative Choir Corporation.
as the said no due certificate could not be issued by the choir board so and so corporation. Because of the contempt proceeding is dropped accordingly.
Item 66. In this case, 66 already order has been compared with.
Compared with
Item 67.
My lord, the order is passed, that is at page 13. The operating portion is minors. That is, we have been third paragraph. We have been initially appointed as lecturer in Odia under the opposite parties 3 and 4.
where is the order?
My
Where is the order?
lord's order was passed on 20th of October 2015. Page 13. Here at my lord, the direction was at page 14. Considering the submissions made by the learned counsel for the party and on perusing the material available of record, it appears that the impugned order passed by the director in Annexure 8 has not been complied with till today by allowing the petitioner to continue in service in view of the matter.
So which is the governing body before the director and the governing body?
My lord, director state.
What is the governing body?
Governing body, my lord, sir.
I am appealing for the opposite party, governing body. My lord, pass over, conducting council is in another court, my lord.
I am appealing for the opposite party number 2, the then secretary of the governing body. Opposite party number 2 was the then secretary for the governing body. I am appealing for him. I think my friend is appealing for the present governing body. Number 3.
But what is this? In that view, the matter, let commissioner file a fresh representation before director.
Pursuant to this order, the petitioner filed a fresh representation. The fact remains there are 3 posts for Odia lecturers, Odia literature lecturers. Thereafter, the OP number 2, the secretary wrote a letter to the director stating that all the 3 posts are filled up. So, in view of the order of this honorable court, what to do? The director did not respond. In the meantime, my lord, the petitioner has already retired. That is 31 January 2016, the date of superannuation already over, my lord. So, in fact, technically, the contempt petition has become infructuous. Reason being, had she given appointment, she would have been continued for 1 month only. And since 2016 January, her age of superannuation reached your order.
I think my learned friend is not aware of the fact. Your lordship can see page 14 last paragraph. I was continuing. I was not allowed to continue. I preferred an appeal before the director. Director passed order and to be reinstated and to join. That was not accepted by the principal. Though a governing body is the competent authority, the matter was never placed before the governing body. No direction, nothing has been taken because the opposite party number 3 from whom he appears was going to be affected. So he prolonged the matter and therefore, my lord, a contempt petition was filed. Your lordship can see at page 17. The first contempt 1756 of 2015. Your lordship was prepared to pass this stated by the learned counsel for the petitioner. That order dated 28 and 225 possession of this has not yet been complied with. If the order has not been complied with, let the opposite parties comply with the same within a period of 1 month from the date of communication of this order. That has also not been complied with, my lord.
No, forget we are on the main order.
Main order is, my lord, at page 14, last paragraph. Considering the submissions made by the learned counsel of the parties and on perusing the material available on record, it appears that the impugned order passed by the director in Annexure 8 has not been complied with till today by allowing the petitioner to continue in service. In view of this matter, let petitioner to file a fresh representation before the director and the governing body who shall
see that the order passed in annexure 8 is complied with. Neither the director passed order nor the governing body.
Your Lordship, kindly at a glance on my reply, my lord.
No, sir,
That is
I'll see your reply, but I'll see the order first, 28/10/2015. It refers to an order passed by the director, annexure 8, whereby his termination was held to be illegal. The director had directed for reinstatement. All right. The court directed that that order should be implemented. Whether that order was implemented or not.
Well, that order could not have been implemented by me. It was to be implemented by the director. Your Lordship, kindly looks at annexure B/2 running page.
The director had passed an order.
My lord, there are three posts for lecturers. All the three posts were filled. So, OP number 2 wrote a letter to the director.
So you could have filed a review application here. You could have filed a review application. You could have brought to the notice of the court that this order cannot be implemented. Annexure 8 cannot be implemented.
That's why annexure B/2.
So you decided to violate.
So what to be done? Since the posts are there, should we create another post? Because the principal cannot create a post, my lord. It is the state, the department, who is to create the post or to let the petitioner.
Why did you not file? Why did you not seek any clarification?
I have no instruction whether they have sought any clarification or not because they transfer.
Clarification must have been there on record. It is not there on record. And this order was passed in 2015. We are in 2024. The court is satisfied based on the allegation made in the contempt petition and the so-called reply which has been filed on behalf of the contemners that a case of deliberate disobedience of this court's order dated 28/10/2015 passed in OGC number 3799 of 1996 is made out. So stop. Who are the contemners?
My lord. Niharbanjan Patnaik is the director and Chintamani Jena is the principal, secretary.
Where are they?
They are my,
Have you impeded them?
yes, my lord. First item. They are the contender opposite party 1 and 2.
1 and 2. Their names are not there. Their names are not there.
Minus have consolidated cost to have filed. That was filed on as per the I filed the consolidated cost to 3 names and the Professor Santosh Kumar Mr. Thereafter the principal secretary, 3 persons.
Is made out. Stop. Let the contemner opposite parties number 1, 2, and 3 be personally present in court on 2 weeks when the court will consider initiation of contempt proceeding against them upon framing charge of contempt of court. Yes.
68. It might not comply with it. If I were registered,
comply with
69. Non-compliance of the order of this honorable court dated 24/7/2015 is the cause of action to file the contempt application. Hearing your lordship,
there is a review petition
pending. They have filed review petition where I have filed my counter too. Now the review is not maintainable. After 2 years, 3 months, 7 days, they file a review. Where another petition they have filed for modification of the lordship's order. While this honorable court going to dismiss that miscase for clarification of order, they withdraw that application and file a review petition. And the review is not maintainable too, my lord. They want the reversal of a losses that is allowed to dismissal.
So review application should be heard first.
Yes, my lord.
Let the let RVWPET 246 of 2017 be listed before the appropriate bench along with the contempt case, along with CONTC numbers also. Yes.
Item 70.
Under the order dated 22nd of January 2016, you'll also get at page 9. The order at page 9 has not been complied with. And on the last occasion on 12/7 and 19/7, my learned friend was directed to take instruction. But
in this case, my lord, the petitioner are staying in a forest land, my lord, in forest land. The petitioner want to settle the lien in their, my lord. The collector has written a letter to the state government, my lord, for dereservation of, because only to the Forest Conservation Act, my lord, there are some difficulty to settle the land in favor of petitioner. And that application is pending ransom time, so that.
No, what is the order?
the order to, my lord, in fact, he is staying, not the petitioner alone, but also 12 persons were affected by the river crack.
Where is the, yes.
Page 9, my lord. Page 9 is the order. My lord, may I place that order? This petition has been filed by the petitioner with a crack affected.
UNTC 1100.
Yes, sir.
Which page?
Page 9, my lord.
Page 9. Yes.
This writ petition has been filed by the petitioner who is a crack affected person due to bank slip of river Budhabarango at Baripada with a prayer to direct the opposite party to settle the land appertaining plot number such and such under Khata number 1513/36 of Mauja Baripada 1 number 12, measuring an area of 8 decimals in favor of the in his favor for construction.
Let us see the direction.
The direction is, my lord, considering the direction, page 5, my lord, paragraph 5, considering
the decision has been taken or not?
No, my lord, not.
My lord, we have already written a letter to the state government, my lord, to settle the land in their favor because the land is in the jungle prison, my lord. So that has to be de-reserved, my lord.
Well, now, my lord, in view of the amendment to the Forest Conservation
What was
Act.
the direction?
My lord.
What was the direction?
My lord has to take a decision, my lord.
Whether that decision has been taken by the collector or not?
My lord, my lord.
Decision has been taken by the collector.
My lord. But so kindly see the letter dated 3/7/2024, my lord. Annexure key I have given that. Last
decision, what can be done?
My lord, so, my lord, that decision, the collector again directed the Tahsildar to submit the proposal. The very proposal was submitted way back in the year 2008, and that is taking into consideration that fact. Your lordship was pleased to direct the collector to take a decision and to ensure that the land is recorded in his name. Because, my lord,
please come to the order. There is no such direction. The petitioner.
Paragraph 5, my lord. Considering the above means your lordship will, the next, the previous paragraph, the petitioner has filed a rejoinder affidavit in court today, along with the letter dated 16/7/2008, issued by the Tahsildar Baripada to the additional district magistrate, Mayurbhanj, having proposal for the reservation of acres 0.88 decimals of jungle kisam land for rehabilitation of 12 crack affected person in Mauja Baripada. That taking into consideration that the direction was given. Now the collector has done the same thing. He has again directed the Tahsildar to submit the proposal. But thereafter, no development is there and
the direction thereafter. See, you want the things to be decided in contempt proceeding. Which was not decided in the writ proceeding.
The direction is considering the above this court dispute of the petition with the direction to the collector.
Alleged disobedience of this court's order dated 22/1/2016, passed in WPC number 19534 of 2015. Relevant portion of which reads thus, paragraph 5, operative portion of which reads thus, paragraph 5. First off, London Council appearing on behalf of the petitioner has alleged that despite the court's order, the land in question has not been settled in favor of the petitioners. First off, it has been submitted on behalf of the estate, on the other hand, that in view of this court's order, a decision has been taken by the collector cum district magistrate Baripada in favor of the Mayurbhanj, in favor of the petitioners.
Subject to approval of the resolution proposal.
Subject to approval of
Resolution proposal of Jungle Kism land.
subject to approval of the proposal for de-reservation of the forest area. Stop. Next. Since the collector has taken a decision in the light of this court's order, violation of which has been alleged, in my opinion, no case of willful disobedience of this court's order is made out. The contempt proceeding is dropped.
71.
No instruction with liberty
No,
to file
no, that
a cause of action so substates.
no instructions.
Item 72.
Yes,
The contempt right for the interim order of the writ petition matter, the writ petition is still pending now.
the writ petition along with this contempt petition along with WPC number 10385 of 2015 before appropriate bench.
Item 73.
Last proposal of
The roster.
sorry. Sorry, last proposal of raised the question of limitation and section 20 of the contempt of court said. Well, let's not kindly say only 22nd July, the government has come forward, their lordships at the ordinance Supreme Court, their lordships have considered all these arguments and said that for the petitioner. Oh, no, that part has also been built in the judgment.
Only that's a Sanjeev Khanna judgment.
Yes, that they will also kindly consider the judgment and they will do so.
Please allow him.
Sorry?
And for the
According to you, the contempt petition is not maintainable.
Yes, madam.
My lord, may kindly see the two orders out of which this contempt arises.
73.
72. Paragraph 3. This was the interim order, and then final order has come about. The interim order was dated 10/7/2012. Pending consideration of the missed case, it is directed that the application of the petitioner for renewal shall be considered in accordance with the guidelines / scales of rates of PPT approved by the TAN fixing uniform rate at par with similarly placed manual iron ore plot holders and
Which order you are reading?
order dated 10/7/2012. This is quoted in the contempt application, paragraph 3.
Yes.
So renewal shall be considered at scale of rates of PPT approved by TAN fixing uniform rate at par with similarly placed manual iron ore plot holders at the ad hoc fee is fixed by port or by TAN, and any deposit is already made, the same shall be subject to result of the writ petition. Ultimately, my lords, in the interim, there were two other orders which were carried to the Honorable Supreme Court, and the Honorable Supreme Court finally dismissed their claim and also didn't say anything about the interim orders passed thereafter. Then finally, this is the order out of which content arises, that is quoted at paragraph 5, page 3.
Yes.
This is the order dated 25/4/2014. The petition is dismissed as withdrawn on the statement of Mr. T. Mishra, learned counsel for the petitioner, subject to the condition that the petitioner will pay the dues of the corporation for the period the petitioner has enjoyed the stay. So after this, we wrote to them on several occasions. Paragraph 7, we have mentioned that it is a continuing cause of action at page 4. And thereafter, my lords, on 36/2014, we mentioned that your dues are to the tune of 7 crores 88,10,625. To this, my lords, their reply, my lord, may kindly see paragraph 3. It begins from at flag B, their reply is there.
Yes.
Now, if my lord would see, one of the grounds which they take is at page 13, paragraph 3F.
Page 13.
Page 13. That is internal page 4 of their reply. Paragraph 3, small f.
Here.
The letter dated 5/7/2012 declining to the request to review the scale of rates was challenged by the present opposite party and some other exporters by way of petitions filed before this honorable court. The exporters were allotted under the same tender notice. It is pertinent to mention here that the license had already expired on 36/2012. Next line, my lord, is very important. Since the plot was vacant, the possession where the plot was taken over by the port trust, resumption of possession did not take place at any point of time. So on affidavit in the show cause to content, this is what they say. This is contrary to not only our records, their proposal pursuant to the orders of the Honorable Supreme Court, where they say that for this period we will pay this amount. So not only have they violated the orders of this court, before court they have stated incorrect facts in this manner. Their own letter, if your lordship would allow me to show, at page 81, this is the proposal which they gave. Annex 13 to our rejoinder at flag C. This is dated 13th of August. I hope my lord finds it. Annex 13 at page 81 to our rejoinder, which is at flag C.
Have you seen that rejoinder?
Yes.
Yes.
Now, my lord, may kindly see Annex 13, page 81. This is dated 13th of August 2013.
Yes.
Now, here, by referring to that plot number, they say that in compliance of the order of the Honorable Supreme Court received online on so and so, we put forth a proposal for commencement of operation at port at the allotted plot number stated so and so. So they give a proposal that this is what we will do. And this clearly shows that they are in occupation of this plot. And other documents in the rejoinder itself would show that cargo was removed after. And as late as March 2000.
Is he raising any preliminary objection or the?
Now, so far as limitation is concerned, he says that it is beyond that statutory period of 1 year. There, my lords, there is one judgment of the Honorable Supreme Court in the case of Pallav Seth, where they say that this rule of 1 year is not an absolute proposal. Now, my lord, may kindly see.
All right, we will take up the matter on the next Friday. So it will take time.
We have already memoirs there, so may found always.
For withdrawal item number 448 to 456.
459.
It's also there.
449 to
448, 449, 450.
Yes, yes.
451, 452, 453, 454, 455 and 456.
455 complied with. For 456 is complied with, I file a withdrawal application. Problem.
Item 74. So,
Withdrawal 324 and.
Let's have a look at the
serial
324 or contempt 4646 item 324. 4864 item 356.
both are followed.
that item 74, your lordship, on complaints of order dated 3/2/2016, your lordship. Last of, on last date, your lordship, giving time to the state to.
Further 2 weeks may be given, your lordship, to seek instructions, your lordship.
2 weeks further time is allowed for the contemners. For the AGA to seek instructions as regards full compliance of this court's order.
88 also similar, Mr. Your lordship.
Which item?
88.
Let that be called.
Item 75.
Yes, dismissed.
Item 76.
On appeal. On appeal. 76.
76, your lordship. Yes. In the meantime, the state has filed a review application pending before this honorable court. Application has nothing to do with this matter. Matter kind of a class of judgment. There they said that the permission granted is valid. Now we have initiated a proceeding because we have deviated the permission and order to construction. That is a separate cause of action altogether. So contempt doesn't apply, my lord. That is what my. Yeah, move before this honorable court challenging the order of revocation of it. And this honorable court has been pleased to pass the order of revocation, and thereafter we have approached before the authority to grant us permission for the construction of the set. And accordingly, the construction, and in the meantime, they have issued notice regarding the deviation of the set premises.
No, but then he is right that is a fresh cause of action.
Yes, sir.
The contempt is not made out. And after and counsel appearing on behalf of the.
And challenging the said order, the state has approached this honorable court in review application 119 of 2017, pending before this honorable court, challenging the title of the property. Yes. The state and filed a review, what my knowledge says that what it is relating to permission granted.
That is different.
Yes, sir.
After having heard counsel appearing on behalf of the petitioner and the opposite parties, in view of the development subsequent to passing of the order, violation of which has been alleged in the present contempt application, in the court's opinion, no case of willful disobedience of this court's order is made out. The contempt proceeding is accordingly dropped.
And liberty must be granted if necessary, the petition may approach before this honorable court, challenging the order of delegation.
Challenging the order of?
Can order I have annexed and
the petitioner shall have, however, liberty to question the correctness of any decision taken by.
Focus notice issued by the media authority.
Legality of the proposed notice.
Yes, sir.
Issued by
the media authority or
by the BDA before appropriate forum in accordance with law.
77.
Where is the order? Where is the order which has been violated?
That time that at the time of filing, I have not filed, my lord. There is a direction to the ADM, my lord, to take a decision. I put in my application and last occasion you also directed my law and.
Yes, have you taken instructions?
Yes, your lordship. We've not been served with a copy. There's no copy with us, your lordship. 78. 77. No, we don't have a copy of it, your lordship.
You have not served.
I'm sorry, on the last occasion, my Lord and Senior Mr. Samantarai was there and his lordship directed to take instruction for everything. There's
Copy 9. Yes, no.
Next week.
That is a riot, joint verification.
78.
yes.
Yes, your lordship, joint verification has been done. And a copy of the report also has been submitted, your lordship.
Yes, thereafter ADM was to pass an order. The direction was there.
I will seek instructions, your
Yes,
lordship.
that's why it was.
Don't address her.
I'm sorry, man. I'm sorry.
Where is the order? So item number
77.
order you are now next.
I have also quoted my lord, but
Where have you quoted?
I'm not at
28.
77.
page number 3, last portion, page 3. Starts from page number 2, my lord. After hearing particular, please direct to conduct a joint verification as per the direction of the Lord and ADM Balesar within a period of 30 days hence, and be report to the Lord and ADM Balesar, and the petitioner shall be given a reasonable opportunity of hearing. The decision should be taken by the Tahsildar by giving reasons to the opinion arrived at by him. After submission of the report, the Lord and ADM Balesar shall take appropriate decision in the matter.
So whether this has been done?
Lordship, I have instructions to the effect that the joint verification was done and a report was submitted to the ADM Balesar, your lordship.
Ask him to be here.
I'll ask, yes, your lordship. By next Friday, we will submit it.
Ask him to be here on Friday.
Friday, let it come on Friday, your lordship. I'll
Friday.
78.
78, your lordship, this is the second content matter. Here, the order is at Annex 1, page 7.
26.
On the previous occasion, the learned additional government advocate appearing on behalf of the opposite party.
What is innocuous? What is the meaning of innocuous? What is the meaning of innocuous?
A prayer that cannot be acted upon.
So your prayer was innocuous, and similar is the direction. Then where is the contempt?
Sir, actually, they had to decide the way bandobast case.
Sorry, we are wasting time. The petitioner has alleged violation of an order dated 24/11/2015 passed by this court in WPC number 18334 of 2015. So it has been mentioned in the order itself that the prayer of the petitioner was innocuous in nature, and the writ petition was disposed of on the very first day when it was taken up with a direction to dispose of a case. What's wrong? Dispose of what is? Bebandobasta.
Yes, sir.
Bebandobasta case. What's wrong? Next. As the order was passed on the very first day when the matter was taken up, without having response of the other side, in my opinion, no case of willful disobedience of this court's order is made out. Contempt proceeding is dropped.
79.
79 complied, your lordship.
Not complied with.
Complaint.
Not complied with, my lord.
Not.
Not complied.
All right.
I will peruse, my lord.
the order dated 11/4/2017. As the operative order is para 7 of the order. Without expressing any opinion on the merit of the case, the writ petition is disposed of with a direction to the opposite party 2 and 3 to examine the case of the present petitioner in the light of the judgment passed in WPC number 18908 of 2013, Radharani Sambal case. After affording of reasonable
Whether the order has been passed or not.
no, my lord.
Yes, Your Lordship, Annexure A/3, Your Lordship, to Ashoka's affidavit. Your Lordship, the last paragraph, A/3, the last paragraph, may read it out, that however pursuant to the above decision by the Government Directorate, the petitioner Srimati Usharani Nanda, classical teacher, Barunai Vidya Pathak, Fakirpada, Cuttack, is hereby allowed the trained scale of pay of rupees 9,300 to 34,800, GPA 4,200, with effect from 5/9/2011 as per the directed letter dated such and such 14/7/2020. That
I am
the
entitled to get the-
Sanskrit teachers also, Your Lordship. Accordingly, pursuant to the instruction received from the Government Director, the order dated 11/4/2017 of the Honorable High Court passed in WPC number 22/7/55 of 2016 is hereby complied.
I am entitled to get the train scale of pay.
That entitlement has not been decided. That entitlement is yet to be decided.
I am entitled to get the train.
You may be
be.
all right. That is not the direction.
Let a copy of the complaints affidavit.
From the submission advanced on behalf of the contemnors, it transpires that this court's order dated 11/7/2017 passed in WPC number 22755 of 2016 has been complied with, in as much as the petitioner's case has been examined in the light of the judgment in case of Radharani
Samal.
Post op. Radharani Samal, and a decision has been taken. Post op. Next, this contempt proceeding, since the order has been complied with, the contempt proceeding stands dropped. The petitioner shall be at liberty to question the correctness of the decision taken by the concerned opposite parties pursuant to this court's order dated 11/4/2017.
Let a copy direction. Give us all a copy.
Give
Yes,
him,
Your Lordship, I'm sorry.
you will get.
Item number 80.
May I please, Your Lordship? That is, the order dated 14/1/2016 has not been complied. The relevant person, Your Lordship, kindly see page 9, that's annexure 1 of the contempt petition.
It's been complied with, Your Lordship. We filed a compliance affidavit also.
Last occasion, Your Lordship, for that reason directed that to file compliance affidavit, whether you have paid that amount or not. So let us.
What is the order?
Order, Your Lordship, page 9, Your Lordship, just have granted. Annexure 1, page 9. Order is very clear, there is no ambiguity in the order, Your Lordship, kindly see, with Your Lordship permission, I am placing. Relevant person, Your Lordship, I am not placing the entire order. In the light of the background, the Director Elementary Education Orissa is directed to transmit service book of husband of the petitioner, namely late Mathu Naik, who while working as peon in the Mission ME School, Ramadua, has superannuated from 31/11/2000 within reasonable period, preferably within 3 weeks from the date of receipt of certified copy of this order in the office of the Block Education Officer, Parala County, and immediately after receipt of the service book, Block Education Officer will do needful and send the same.
See, this order was only for the purpose of issuance of final payment authorization.
Time limit was given, direct.
Right, time limit they have violated.
Your Lordship will see, the last person, Your Lordship, 10% interest will accrue, and if the final pension authorization order will not be issued within the period stipulated herein above, the entire amount will carry interest at the rate of 10% per annum from the date of this order. The interest amount will be recovered from the pocket of the hearing officer after fixing accountability. Now, Your Lordship, this order is very clear. Now, Your Lordship is to see when this order was passed, whether within that period that disbursement has been made or not. Because Your Lordship know
That is, whether order has been complied in true letter and spirit or not, that is.
Your Lordship, the family pension in favor of the petitioner Mary Nair, wife of late Matthew Nair, has already been authorized by.
No, the interest part.
The interest part, Your Lordship, I'll seek instructions because it only given a copy of the.
See, so far I have been very indulgent. And now I am gathering an impression that unless I start punishing the contemners, the situation is not going to improve. So if your officers have decided for that, then I am also ready. Who had to comply with the order?
Madam, that is director and your lordship will see. And opposite partner of the district inspector of school Kerala Committee. Opposite partner 2 and 3, because director will send that paper to the opposite partner number 3. Then opposite partner number 3 will send it to the accountant general. That is your controller of accounts, and your lordship will see. Controller of accounts has also written a letter to them that this is most urgent, you send this. That is Annex 3. I have annexed that document.
Who has violated the order?
My lord, 2 and 3, both joint your lordship. Because 2 and
Who is 2?
2 is director elementary education.
Director cannot commit contempt. Person can commit contempt. So who is the person? You have not implemented.
That is your lordship.
Then we cannot. The present contempt application. Sorry. Not after so many years, 7 years.
I know.
The petitioner has raised deliberate disobedience of this court's order dated 14/11/2016 passed in WPC number 14582 of 2012. Stop. The persons who according to the petitioner, have committed contempt of court have not been impeded in their individual capacity. So stop. Since the order violation of which has been alleged was passed on 14/1/2016 and the contempt petition was filed in 2017, I am not inclined to entertain this contempt application 7 years thereafter by permitting the petitioner to implead the contemners. So stop. The contempt proceeding is accordingly, this contempt petition stands disposed of.
Sorry for interruption. Name is there. We will assume the page 2. The lordship kindly see. The page 2 of the contempt petition.
Just a minute.
Mr. Thakur Pratap
Next time is 81.
81. It may lordship that is that page 2. The name is there. Name of the hearing officer.
81.
Second order, lots of directors that comes to obtain instruction.
Just a minute.
Sorry.
Where? Which item?
Previous matter is 80.
Previous.
80.
My hearing officer name is the page 2, your lordship.
Just a minute. No, who has violated?
My lord, that is opposite party number 2, your lordship. Block education officer, Kerala Committee.
Opposite party number 2 has not violated. Interest part he has not violated.
But your lordship, I could not understand your lordship because hearing officer, that is the question, your lordship. But your lordship, widow or old widow house.
I think it goes without saying, however, that the petitioner shall be at liberty to claim payment of pension, payment of interest as was directed by this court in its order dated so and so before appropriate forum.
81.
But it run on 2nd August, will also directed it run to approve some other order.
Your Lordship, 2 weeks' time, we'll file complaints.
This is 2017. What is happening?
Lordship, we've already intimated them last week. We've sent them a letter, 2 weeks' time.
Let us see. 2 weeks further time is allowed for when AGA to seek instructions and file compliance affidavit. Yes.
82. Like 82, my lord, the present petitioner in this case, present petitioner died. I have filed a subsequent petition that is the I number 363/2024.
Whether order has been complied with or
Not
not.
complied with it till late, my lord.
Where is the order?
Your lordship may kindly have a glance to page 15. Order dated 28th June 2017, my lord.
What was the order?
Had Lorna counsel for the petitioner and Lorna additional government advocate, the limited grievance of the petitioner is that the land in question in Halkata number 147/42 stands recorded in the name of the deceased husband who died on 11 December 1994. However, the petitioner not been able to get the mutated in favor of the legal as of the
Lordship may see para 4, 5, 6, and 7 and 8 of our affidavit, Your Lordship. There we've said that the pata that the petitioner has placed before the authorities doesn't have the signature of any official, Your Lordship, neither the Tahsildar nor of any other revenue official, Your Lordship. And since the mother Tahsil also, the records are not available in the mother Tahsil of the Tahsil was bifurcated. And the mother Tahsil record room also doesn't show any pata being handed over to the petitioner's husband, Your Lordship. And in the bullet also there is no record, Your Lordship.
Under the Annex 1, this is the certified copy obtained from the office of the Tahsildar, my lord.
But it doesn't have a signature.
This record is in the name of my husband.
Maybe Mr. Counsel, you file a writ petition.
My lord.
The writ petition was taken up.
Taken up.
And when it was taken up, it was disposed of.
Disposed of.
All right. Without any counter affidavit, without anything.
My lord.
With her direction to do whatever has been directed.
There is
no other legal impediment. So that is the impediment.
Impediment whether there is a legal answer is there or not. But I am the wife, after death of my husband,
you are the wife.
Land the record
you are the wife.
I am the wife.
Who says?
The record stands.
Who says that you are the wife?
I have shown the affidavit, I have filed all the documents.
Therefore, you are the wife.
I have filed the birth certificate, legal certificate, my lord.
The petitioner has alleged disobedience.
That the son of a Khalilakwa. In the under the certificate, I have obtained the certificate copy from the complaint authority, that is Tahsildar, my lord. And if you after death, my husband,
why did you not tell the court that instead of passing this order, the state authorities should be directed to file a counter affidavit? The parties should be noticed. Did you make the submission?
Well,
you accepted this order.
Well, I oblige before my lord because it is the honorable court passed the order, but on the very same day when the matter is taken up, the honorable court has disposed this matter directing the revenue inspector to accept the warrant, my lord. It is a question of accepting the warrant, my lord. But I either accept the warrant, he is disputing that. Now the land is not recorded. The stroke of the file by the government not sought in the they have taken stand. Even if the order of this honorable court, my lord. My lord has a grant.
When there is no order, no so-called file, no
sought to me. Even the order of this honorable court.
The following is the order passed by this court dated 28/6/2017 in WPC number 11625 of 2017, which is said to have been violated. Stop. Next. The order was passed on the very first date when the writ petition was taken up by this court without notice, without giving opportunity to the other side. Stop. In such view of the matter, other side to respond. Stop. In such view of the matter, I am not inclined to entertain this contempt application. 7 years, more than 7 years after the order was passed, stop, the contempt proceeding is dropped.
Item 83.
In this case, my lord, I have received the so-called affidavit filed by the state, my lord. I need some time.
What is the order?
What is
the order?
Order of the writ petition, my lord.
Yes, yes.
The proposal has to be sent by the.
What has been violated?
But
where is the order?
Order, my lord, page 2, I have quoted in. Page 2, paragraph 2.
Same thing. To take decision in the matter of proposal. The petitioner alleges disobedience of this court's order dated 23/3/2017, passed in WPC number 5012 of 2017. So the petitioner claims to be an NGO. So following was the order which was passed on the very first day when the writ petition was taken up for admission, paragraph 2 of So considering the nature of the order passed by this court and the fact passed by this court, I am not inclined to take cognizance of the alleged disobedience of cognizance of the alleged contempt of the court 7 years, more than 7 years after passing of this order. The contempt proceeding stands stopped accordingly.
84.
My lord, matter is the rehabilitation appointments, my lord. Rehabilitation appointment. My lord, Annex 1, page 7, my lord, order. Not complies with 21st June 2017 order, my lord.
What is the order?
Yes, my lord.
What is the order?
Order, my lord. Consider page 7, my lord. Condemnation. Annex 1. Relevant portion, last para, my lord. Considering the rival of contention of the party and taking into consideration the pleadings and the observation of this court in the direction of Ritanjali Giri Supra, the writ petition stand disposed of, which direction the opposite parties authorized to extend the benefits.
2 weeks time, your lordship will file a show cause, where files instruction as to what has happened after the plea, whether they complied or not. 2 weeks, your lordship.
Content number 3, file show cause, my lord, para 9, that the defendant could not comply the order of this honorable court, but the region of instruction having not receiving the government in school and mass education department.
Your departments are taking treating the orders of the court as rest papers. And unfortunately, these matters are pending for 7 years. Nothing can be done now. File your affidavit. 2 weeks' time is allowed for the contemners to file a compliance affidavit. So it is made clear that the courts shall consider initiation of contempt proceeding in case this court's orders is found to have not been complied with till the said date. Till the next date. Yes.
Item 85.
85 minutes already we have complied with the order, just show a moment. And we have given this, the content committees for work, but let's say we just have a glance. Check order, just Mr. Pali. Order number 14, dated 7/2/2024. Let's get it.
Just a minute.
Just your lordship may have my affidavit. Order number 14, dated 7/2/2024.
Yes.
This matter is taken up to on perusal of the affidavit filed by the opposite party number 2 and 3. This court does not find any satisfactory reply. This court is of the view that regularization of the service of the petitioner should have been done from the date of the joining the post as was appointed against the sanction post by way of valid selection process. Hence, this court as well as the appeals court have held the pattern of decision that regularization of service should be done from the date of joining, not from the date of judgment. The opposite party contender directed to file an affidavit in light of the above observation. This order was challenged by opposite party 2 and 3 in a weak appeal. The weak appeal order is at Part K. Part K of your lordship's brief. Part K. That is the office code Part K. The operative person, your lordship's order. At paragraph 10, your lordship said that paragraph 10, there is no call. Let's get it. Judgment passed in weak appeal.
Yeah.
Paragraph 10, there is no call over the principle that even an interim order passed in a contempt proceeding in appropriate cases can be subject matter of challenge in an intra-court appeal on the first term of the letter petition Patna High Court. However, we are of the considered opinion that it will be open for the university to take such plea as may be available to satisfy the court hearing the contempt petition proceeding, that there has not been any disobedience of any terms of the order passed by the single judge. In the present facts of circumstance of the case, we are not inclined to interfere with this state in the present intra-court appeal. Now, my land trade today has filed an affidavit that they have given it from 2015 to date of judgment. That had
been challenged.
That's exactly what I'm saying. Also, not liberty, so that
from the compliance from a compliance affidavit which has been filed on behalf of the university. There does not appear to be any dispute that this court's order, violation of which has been alleged in the present contempt application, has been complied with. So, next learned senior counsel appearing on behalf of the petitioner has however submitted that the petitioner is entitled to regularization
from the date of joining.
From the date of his joining, which has not been done in the present case. Stop. The petitioner shall be at liberty to ventilate this grievance before appropriate forum in accordance with law.
Great.
86. 86 for non-compliance of the order.
Contempt.
9 to
86.
Non-compliance of order dated 9 to 2017, which was subsequently confirmed by the Honorable Apex Court. And last revision, Lordship had directed the state government to comply with the order. Till they, whether they have complied or not.
Yes, your lordship, you have complied, your lordship. We have complied.
Copy notice.
I'll
Complied with.
87.
No instruction.
No instructions.
88.
And the non-compliance of order 3 to 2016, similar to item 74, you will see.
74.
2 weeks after. 89.
may I submit on behalf of Mr. Sahu Minor, non-compliance of the order dated 24/3/2017 as per 12.
That is non-compliance of an interim order.
No, man, final order. Thereafter, they preferred the writ appeal and writ appeal has been disposed of. It has not been entertained and thereafter they have not complied. And contempt has appeared and
What is the order?
page 13, the relevant portion. There is some period this year. No, government is not. College principal of the college, it has been directed to government has allowed my claim, but principal is not carrying out the claim. For that reason, I have filed the writ petition. And this honorable court directed the principal of the college to carry out the order passed by the director. College, my lord, aided educational institution.
Private?
No, my lord, aided educational institution. Government aided educational institution.
So you'll have to issue notice.
Again, notice will be issued, my lord, because the contempt is appearing. Mr. Das is appearing.
It's appeared, your lordship.
Yes.
Samir Kumar Das, my senior colleague, he has appeared on behalf of the contempt.
He is appearing.
Srikanta Kumar Sahu.
No, on behalf of Sahu, I am.
Then Samir Kumar Das.
Samir Kumar Das is appearing.
Appearing for the college.
Contempt. May I take again the notice? May I take again the notice?
Why?
No, madam. I'm going to pass my lord. He has the message. That time the principal will return, my lord. I have no instruction. Next week I will take instruction that I will.
As requested on behalf of the contenders, list this matter. 1 week.
Item 90.
Your lordship, in the present contempt, the operative part of the order which has not yet been complied is an annexure 1, running page number 48. Para 18B.
What is the order?
The petitioners who had approached this court after retirement on attaining the age of superannuation and in the meantime have attained the age of 60 years shall not be entitled for arrears of salary. However, they will be deemed to be continuing in service up to the age of 60 years. In their case, the ORIDA shall treat their age of superannuation as 60 years, fix the pay accordingly, and refix the retirement benefits like pension, gratuity, etc. On such calculation, they shall be entitled to arrears of retirement benefits after adjusting the amount already paid.
So who has not complied with?
Worship the chairman, ORIDA.
Chairman?
Chairman, ORIDA, Odisha Renewable Energy Development Agency.
Someone is appearing.
No, your lordship. Notice.
So which part of the order has not been complied with?
18B, that part. 18B.
18B.
Yes, your lordship. The present petitioner comes under 18B, your lordship.
Yes.
Not there.
State is not the council, your lordship. ORIDA.
Notices were issued.
No, your lordship. Notice.
Issue notice. That is only for the purpose of determination of your pension.
Yes, your lordship.
1 week. 6 weeks. Yes.
91.
Obliged to question.
It will please your lordship. This is the second contempt.
Forget second contempt. Where is the first order?
The second one, the
Second contempt.
Where is the order in the writ proceeding?
Order. Page number 8. Hard law and counsel for petitioner, it is stated that the order dated 13/1/2016 passed by this court in WPC number 379 of 2016 has not yet been complied with. Where the authority complied.
Where is the order, original order?
Original order, that is in that is passed in actually WPC number 379 of 2016. The original order, that is in content number 1380 of 2016.
Mr. To the orders passed in contempt cases, where is the order passed in the writ proceeding?
Writ petition, that writ petition order it is enclosed as annexure 1 in WPC number 379 of 2016. That is there, my lord. The order is operative considering contents and
what are you reading? Where is the order passed by this court?
That is in content number 1380 of 2016.
Where is the order passed in the writ proceeding?
Writ petition, that is the order. That is the order.
That is the order.
That is annexure 1 in content number 1380 of 2016.
Very difficult. It's very difficult to understand. I am repeatedly asking where is the order which was passed in the writ proceeding? Where is that?
That order, that is the annexure 1 in content number 1380 2016.
So that order has been passed in contempt case.
Contempt case.
But where is the order passed in the writ proceeding?
That is the order passed in actually WPC number 379 of 2016.
Where is that order?
That order is annexure 1. Annexure 1 annexed to content number 1380 2016. So that order was not complied. So for that reason, I prefer the present content, that is content number 95 of 2018, the present content. And prior to that, there was the earlier contempt petition, that is contempt number 1380.
Earlier contempt petition.
The earlier contempt petition, the first contempt petition. And that order is also annexure 1 in WPC number 379 of 2016 passed. That order, that is annexure 1 in contempt number 1380 of 2016. That is last time also your lordship wanted to know what the order passed by the commandant. That is passed in.
Mr. Counsel, please try to understand. My mind shall not work unless you show me the order passed in the writ proceeding.
The writ petition. That is the annexure 1 in content number 1380 of 2016. Page number 6 to 9. I need to permitted to read out that order.
To consider is that has not been considered.
Your Lordship, we have given a show cause reply in that the order was in that if I may read out, Your Lordship, it was said that the Commandant Home Guards Raigada is directed to consider the case of the appellant for appointment as a home guard. If there is a vacancy in the district, if he submits application in prescribed form A as per Rule 4 of the Orissa Home Guards rules, if he is found suitable meeting all requirements and qualifications including age, medical fitness.
So where are we going?
In 2015, there was a board, Your Lordship, conducted. The petitioner had not taken part in it. Then he was intimated by letter that there are no more vacancies. All vacancies have been filled up. If at all in future a vacancy arises, and he will be intimated, Your Lordship.
So the decision has already been taken.
Yes, Your Lordship. Annex A/1 is the letter intimation to the petitioner, Your Lordship.
Actually, that was challenged in the read petition. That is WPC number 379 of 2006.
Mr. Counsel, please see what is the order passed by this court. Do you have a copy of the order with you?
Yes, the copy of the order has been annexed in with.
Yes, now the order is there with me. Can you see what is the direction?
That is the direction is considering the contentions raised by the Law and Counsel for the petitioner. This court disposes of the writ petition directing the opposite party number 3 SP Commandant Home Guards Raigada to consider the case of the petitioner in view of the appellate order passed by the Commandant General Home Guards Odisha by the Annexure 2 within a period of 4 months from the date of publication of this order.
The order has been, they have considered, the commandant has considered.
They have, yes, they have considered that order, but thereafter this writ petition was filed.
Which writ petition?
That is WPC number 379 of 2016.
$379 of, what are you talking? The petitioner has raised disobedience of.
That is Annexure 3.
See, Mr. Counsel, you are not.
Annexure 3.
You have not understood. This order was passed in 379 of 2016.
Yes, ma'am.
When the court is pointing out that the order has been passed in accordance, the decision has been taken, you are saying that decision was challenged in 379.
379, yes, my lord. That is Annexure 3. That is Annexure 3, page number 14 to 16, in WPC number 379 of 2016.
Petitioner in the present contempt application has raised disobedience of this court's order
That is
dated
page number
13/1/2016, passed in WPC number
216. It is there.
379 of 2016, which was disposed of.
My lord, they have
the
just
direction to the
reiterated
Commandant
that.
Home Guards to consider the petitioner's case in the light of an appellate order passed by the Commandant General Home Guards Odisha. Full stop. Next, it is specific case of the contender that the Commandant Home Guard Raigada has considered the petitioner's case in the light of the appellate order, aforesaid appellate order, and in the absence of any vacancy,
Yes.
he could not be appointed against post of
Home Guard, Your Lordship.
Home Guard. So stop. In such view of the matter, no case of deliberate disobedience of this court's order is made up. The contempt proceeding stands stopped.
Item 93.
And just 1 second, that has been annexed, the order of the commandant has been annexed.
Your 1 second is 2 hours.
That is WPC number 379 of 2016, Annexure 3.
93, sir. No.
Yes. Someone appears.
94.
94, my lord, I am virtual lordship. Last occasion, your lordship directed to comply the order, my lord. The order I have quoted, my lord, that in my contempt petition at verse 9, order dated 10/1/2018. Order was to dispose of the representation, my lord, after giving the due opportunity of hearing.
We've sought for instructions, Your Lordship, 1 week time next Friday.
1 week further time is allowed.
95.
95, my lord. Annexure for order dated 6/10/2009 has not complied. Order dated 6/10/2009, annexure for not complied, they have given time. Complaint take time to make compromise.
What was the order?
Order annexure for dated 6/10/2009. Page operative portion of order, page 38. I read, in view of the above, the writ application is allowed and the impugned order is quashed. Opposite party number 2, Commissioner for Workmen Compensation called Assistant Labor Commissioner Cutter, is directed to take step for recovering the compensation amount or in term of order dated 31/2008 and a payment thereon to the petitioner as earliest no cost. So order dated 31/2008 annexure through page 25. That order has not complied.
Who was to comply with?
Commissioner of Workmen Compensation continues to take time to your lordship in what occasion take time to make compromise. Continue to take time. Last occasion, continue to pray this honorable to
be contempt.
Commission of the Misal. So Misal, name is
This is 983.
this one. Madan Mohan Pai, Joint Labor Commissioner Commissioner for Employee Compensation. He is the contempt.
Yes.
Your Lordship, we had filed a further affidavit, Your Lordship, and that was because there's an order of the Lok Adalat. It was placed before the Lok Adalat, Your Lordship. If I can read out, the Commissioner had stated, if I can read out the paragraph. Therefore, the direction of the Commissioner to pay penal interest at the rate of 12% is set aside, and the appellant insurance company is directed to pay interest of 6% per annum on the awarded amount from the date of filing of the application till the date of deposit of the awarded amount. The amount shall be deposited within 6 weeks from today. If the amount is not deposited within 6 weeks from today, the earlier direction issued by the Commissioner to pay penal interest shall revive. This was the insurance company, Your Lordship.
I am trying to see
to make the payments.
So called affidavit filed at age 35. Container himself admit and based on conditional apology of before that para 14 application that there has been delay in complying with the judgment of honorable court, the order which is earlier intentional not delivered, but for the reason stated above, the deponent sincerely regret and delay and render on apology of the same. Bad apology.
Lordship, the delay was on the account that there was a numerous litigations that was followed by the insurance company, Your Lordship. Series of cases were filed by the insurance
Come
company.
to the order.
Order is directing the order post. I am placing the order. Order that is annexure 4, 38. Order
4 annexure 2.
Annexure 2. Annexure 2 order is that the WC case number 493, page 26. Order in question I am reading.
Yes.
That the WC case number 493D 2000.
So what is the direction?
Direction given to pay or to the direction to whom? Insurance company.
Why are you blaming the government then?
Because they have been directed to recover the amount from the insurance company.
Let us see the order.
Yes. That is the annexure 4 order, the direction given by this honorable court in the WC case that recover the amount and pay the government. That is the 30.
Please read the order.
Yes. In the read, in view of the above, the read petition is allowed and the impugned order is quashed. The review of quashed. Opposite part number 2, Commission of Workmen Compensation.
Please read the order.
What order?
Please read the order. Order is page 24. Order page 11.
Order 24.
Which order has been violated, Mr. Counsel? Annexure
Order violated. That is the WSPC case number 1304 2008. There are review application allowed. I am challenging that review application. I saying that the review is wrong. Final order of commissioner is not complied and review applied. That order I am challenging WPC case. WPC single was by hearing all three parties, this order given. That I have also. Order that 10/9/2000, yes, order 10/9/2009.
Which annexure?
Annexure 4.
The 983, na? Well. Annexure 4 is 6/10/2009.
Yes, that has not complied.
Right, let us see. What is the order?
Order is last para 15, page 38. That annexure 4, in view of the, after considering all the things, the single was said in view of the above, the read application is allowed and the impugned order, the review order first. Opposite party number 2, Commissioner for Workmen, Corporation, Accident, Labor Commission.
Very difficult, Mr. Counsel. This is the writ order passed in writ petition.
Writ petition.
Where is the direction?
Direction for page 38. This I am pressing, again and again I am pressing, that is the order.
Page
38. Paragraph 15, page 38, annexure 4. That read petition arrives once our past. They without a file appeal.
Can you understand my problem?
My doctor.
I have not been able to understand anything.
Yes.
So you are referring to annexure 4.
Yes.
I am there at annexure 4. Annexure 4 starts from page 28.
Complete. 28, 29, 30 started, and so forth. For 28 to 38, 33, 34, 35, 36, 37, 38. That is another annexure.
All right. It begins at page 34. I cannot come that side to see your brief. Which page? It begins at 28.
Page 38, annexure 4.
Page 38. You want me to see page 38?
38, order for para 15 on proceed. Offering is part of the order, I am proceeding.
Yes. Yes, so this order has not been complied with.
Not been complied.
Yes, what is your stand?
Your Lordship, we see your compliance affidavit, Your Lordship, show cause your affidavit, Your Lordship, para 4, Your Lordship.
Yes.
Para 4, if I can read it up. That in pursuant to the above said order, Your Lordship, the one that is quoting, the petitioner filed a contempt petitioner bearing contempt number 987 of 2018 before this honorable court, and the honorable court on 23rd 6, 2022 passed the following order. That I, Mr. Mahapatra, learned advocate, appears on behalf of the applicants and submits that there has been willful and deliberate violation of judgment dated 6 October 2009, passed by this client's writ petition allowing it. He submits office of alleged contemners sought to avoid compliance by initiating several proceedings. Actually, several proceedings were initiated by the insurance company, Your Lordship. Finally, Your Lordship, Your Lordship, that is on para 11, Your Lordship, we have stated that finally on 2/2/2018, Your Lordship, the commissioner has ordered to recover the decretal differential awarded amount of rupees 13,71,494 along with accrued interest thereon from the date of receiving the order of this court dated 14/5/2015 from the account of OP number 2 and with a further direction to deposit the same by 21/2/2018 for disbursement to the applicant's, Your Lordship. Because this matter went to the Lok Adalat and finally it was decided there, Your Lordship. After that, this order was passed for recovery, Your Lordship. So we have complied, Your Lordship, from the insurance company has to pay the amount, Your Lordship.
No, my lord. No. Order attending final. They have challenged appellate court, they have challenged. Matter is that in WC case to one final order that what is filed appeal that has been dismissed by the honorable single judge that I annexed.
Come to the direction.
My lord,
Come to the direction.
the order of the.
Come to the order again, page 38.
38. 38 in view of the above, the writ petition is allowed and impugned order is passed. The opposite party number 2 Commissioner for Work and Compensation Assistant Labour Commissioner Qatar is directed to take steps.
Please stop. Directed to take steps. That's all. Then
Take step to recover the compensation amount.
recover the compensation. The steps they have taken.
No, they have not taken any step to recover the compensation amount. Not taken, what is taken, that is other occasion. That is the other cause of action. But in this case, they are not challenging in appellate court.
Have you filed any reply? Rejoinder you have filed.
They have their own rejoinder, affidavit, they admit their fault, saying that your lawsuit can flag away. The flag A rejoinder affidavit dated 39/2022. They are admitting everything. They contain admitting are based on conditional apology for their non-compliance of the order.
Conditional apology is tendered in every so-called reply, Mr. Counsel. And that doesn't mean that they have committed contempt and therefore they are tendering unqualified apology.
I am not getting any complaint now. 40 lakhs now complaint list. They have given other occasion only that.
And what matter had gone to Lok Adalat?
Lok Adalat, that is the criminal interest. That is separate cause of action. So they have not paid the amount, not gone to the honor appellate court. Then they say the commission, I have not complied with the order. Commission imposed interest after section 4A. That is separate matter. That is appealable. This they say for that commission imposed our penal interest 12%. I say penal interest I shall see if they are ready to pay. I am ready to comply. That doesn't mean this order is gone. The honorable High Court order not complied. That order now satisfied. Even now, order that the 6/9/2009 not satisfied by only appellate court. Division means compliant the order, single 4/6 means compliant that order. That has not been satisfied. Other courts have disturbed the commission that I have complied. That is the different thing. Order 78/2012 has been satisfied, not 6/10/2009. That is in prevailing. That is in existence.
Come to paragraph 11 of the so-called reply.
So-called para 11, yes. In reply to the averment made in para 11 of the content petition, it is humbly submitted that it is a fact on the record that Commissioner for WC case, WC Act 1923 from Division Labour Commissioner Qatar has been pleased to pass order dated 39/14 and 12/2/18 to the opposite party number 2 with the direction to deposit the shortfall decretal compensation amount in accordance with the binding order passed by the Honorable High Court in WC case number 13042/2008, in WA number 11/2010 and F4 number 40/2010, F4 number 41/2010, F4 number 42/2010 with 15 days from date of order having which liable to pay.
This is how they say that the order was complied with. The order has been complied with. This is the explanation.
They have not, order has not complied. So for that different order, commission says that I have misconstrued the order. So I have.
No, he has not. His predecessors had.
Yes.
Not that he says he has complied with. His predecessors might have misconstrued the order.
Mr. Mulan sir.
The
Insurance company has not paid the amount, but I have paid. Poor man is not getting the compensation amount.
the petitioner has alleged deliberate disobedience of this court's order dated.
I am not getting any amount in person of this honorable court. 30 lakhs now, we have to pay insurance company pay
In
commission.
2009 passed in WPC number 13042 of 2008. Stop. Following is the operative portion of the order. Last paragraph. A so-called affidavit has been filed on behalf of the Joint Labour Commissioner Cuttack, stating in paragraph 11 as under. Stop. Next, on the said order, from the said government made in the so-called affidavit, I am of the view that no case of willful disobedience of this court's order is made out. Stop. Next, learned counsel appearing on behalf of the petitioner has, however, submitted that the petitioners have not been able to give the fruits of the judgment of this court rendered in their favor. Stop. This is what can be done for them.
If they can file a contempt against the insurance company, or a direction can be issued to the insurance
No,
company.
direction was to you. No further direction can be given, but what can be done?
Your lordship, 1 week time may be given so that I can see the present status, and accordingly your lordship may pass an order.
Matter of 1 week, the court expects learned AGA to seek instructions as to whether the amount in question has been recovered or not and dispersed to the petitioner. Recovered from the insurance company and dispersed to the petitioner. Yes.
96.
86 and 87, same. 86 also same.
96 and 97.
96 and same.
Item 98.
And second contempt, the writ petition order is annexure 1, page number 9, lordship. From top to bottom, fourth paragraph, the operating part, lordship.
File first representation
Lordship.
within 2 weeks. Audit.
My press representation on under annexure 2, lordship.
No contempt. The petitioner has alleged disobedience of an order of this court dated 11/4/2016. Asked in WPC number 5021 of 2016, whereby the petitioner was given liberty to file a first representation before opposite party number 2. And opposite party number 2 was directed to dispose of the said representation by passing a written order. So the order was passed on the very first day when the writ petition was taken up. So considering the nature of the order violation of which has been alleged, and the fact that the petitioner filed the present contempt application in 2018 while alleging violation of the order dated 11/4/2016. I am not inclined to proceed in the present matter. This contempt, the contempt proceeding is dropped. Yes.
99.
After 99 years of the Honorable Mr. Pradhan has no instruction.
No
We have complied, your lordship.
complied with.
100. No.
On appears.
101.
Note the ordering the writ petition is at page 6. Noting is a show cause reply has been filed, but I have not been served with a copy.
Whether it has been complied with or not, unnecessary wastage of.
And your lordship may just pass over. I will go through your lordship's physical file so that
Physical file.
that show cause reply from that.
Only you can get
No, it is not government. It is OSRTC.
representation.
Then your lordship may grant me liberty to approach again.
Petitioner is alleging disobedience of this court's order dated 13/4/2017, whereby
Annex of the
passed in WPC number 13638 of 2007, whereby the petitioner was given a liberty to file this representation. And the before which authority?
For the opposite party number 1, mother.
There, that is not mentioned. Nothing is mentioned. Which authority? Authority. Such representation and the concerned authority was directed to consider and dispose of the said representation. Also, considering the nature of the order, violation of which has been alleged in the present contempt application, and the fact that application, I am not inclined to proceed in the present contempt matter more than 7 years after passing of the order. Stop. It is
Madam, your lordship may grant me liberty to approach again if
the a so-called reply has been filed on behalf of the opposite party, stating therein that the representation has been disposed of on 7/10/2017. Stop. And counsel for the petitioner seeks permission to question the correctness of the said order dated, question the correctness of the decision taken on the petitioner's representation. Stop. It goes without saying that the petitioner shall have such liberty.
102.
Hello, just now there's some one that compliance affidavit. From that it is SLP has been filed and the SLP is likely to be listed on 6th of August 2024. Let it come after the disposal of the SLP.
So when was the SLP filed?
2018 notice has been issued and he has appeared.
No contempt.
That is likely to be listed on 6th of August.
Maybe, but no contempt. After disposal of SLP, you may file whatever.
I may get it, I may not get it. Thereafter I can file it.
It is not in dispute that the order of this court, violation of which is under challenge in the present appeal, present
Not in dispute that the order of the court violation of which is
A violation of which has been alleged in the present contempt application is under challenge, is subject matter of challenge before the Supreme Court. So stop. In such view of the matter, the disobedience on the part of the contemners cannot be said to be deliberate. Stop. The contempt proceeding is accordingly dropped.
I was going to say not pressed. Because otherwise might have been not pressed. For the time.
In such view of the matter, learned senior counsel has submitted that in such view of the matter, he does not intend to press the contempt application. The contempt proceeding stands dropped as not pressed.
103.
Further time is allowed for the contemners to. Further time is allowed for the contemners to file a compliance affidavit.
104.
It is operated from the page 10. It will go out from the record. That is basically direction is being given by the judge on the order of part 30 for real of God with respect to the case word and still confirm the order. However, the is not taking of the if you will confirm the order of the judge then this order will pass the
contempt petition.
Nature of the answer to the this court discusses the directly to the your please that the dispute of the English application of the immediate and all parties concerned and take a decision quickly according to the role from the date of production of the by the order all I produce a certificate of journal and he never noticed me, not noticing other opposite parties, and never did for the main my immediate application level that is number. Sorry, 850 is something pending for this. He never noticed me. I'm
losing my direct personal appearance of the person.
I'm losing my landman. I've been consolidation operation. I have got 13 lines. This is the order of the the order of the yes. This is the order of the meeting.
Just a minute. Heard the petitioner in person. Stop. Learned AGA does not have any instructions as regards compliance of this court's order dated 33/2018, passed in CONTC. Where is the order? 19 to 2017, page 10.
Page 10.
Order dated 19/4/2017, passed in WPC number 5401 of 2017. No problem. Then AGA does not have any instructions as regards compliance of the said order. Stop place this case on Friday. On which day? Friday? When? The Tahsildar Cuttack shall be required to personally. Tahsildar? Tahsildar shall be required to be personally present in court.
Number 106.
Six hundred already complied.
107.
107. Complied.
No one appears complied with.
108.
The order, in respect of which contempt is alleged, is 32 ballots. The reproduction. the disputers before this court belongs. Person has to get
Which
the
annexure?
annexure 4. At page 32 is the operative portion belongs. Page 32. Considering above and this court finds reformed aspect involving the person is pending only for approval of the board. This court, while allowing the interim order details for answer to continue for a period of 2 months, directs board of directors of WESCO and GRIDCO, so the Secretary Energy Department to sit together and finalize the issue of refund adjustment of a sum of rupees 21,53,000 involving the personal, but taking into account the development through order of height annexure 10 and 11. Annexure 10 and 11 is a recommendation of the executive of the chief engineer of WESCO.com that yes, person is entitled for this refund, but they will take a decision. And the WESCO said that GRIDCO has to take a decision. That's why court said they will finally take a decision in this matter. Person is clearly entitled. Previous page code mentions that we can listen the previous page. There was dispute at the bar that for the recommendation the person is entitled to exemption from minimum charges, and consequently the person is also entitled to refund, which is still pending for final approval. WESCO minutes.
What is WESCO?
WESCO is Western electrical circle. Because Odisha has been divided by 4 electricity distribution divisions. WESCO South. Now all have been taken over by Tata Power. So I am not Tata Power in this party. So direction was to take a decision on this because I was entitled. Court decided I am entitled. But court said they has to take a decision, final decision. That's a court directed them.
So they were directed to sit together
and take a decision.
Finalize the issue.
Yes.
That has been done or not?
And there's a first content court was said in this time.
First content, second content.
So till now, lots.
But who is required to do?
And
who was required to do?
In fact, board of directors of WESCO and GRIDCO.
Have you implemented all of them as part?
Yeah, they have been implemented as part. And these orders have been communicated to the members.
Notices have been issued in the country.
First time it has come. Several times I have given notice for listing, last time not comments. First time they have come. I have noticed results.
Yes. Arbitration matters. Arbitrations are short. Arbitration matters shall not be taken up. I will take up contempt matters, more contempt matters today. Next Friday. Next week. Current contempt arbitration matters will be taken up next Friday.
There are some old revision matters.
Old revision.
Criminal revision matter. After the
Criminal revision, I'll take up at 4 or 4 बजे है क्या? No. Take up old criminal revision. Yes.
The 109.
109 complied. 110 complied.
Complied.
11. 110 complied. No complied. One more complied. But not compared to it is partly compliant. That land was in 90 decimal.
What was the direction?
Direction was as per annexure. Annexure 1, page 4. Government land. They have recorded their name in Tata.
What was the direction?
Direction was to it is in view of the nature of prayer made in writ petition, the court directs the Tahsildar Secretary to comply with the order as at annexure 1 as expeditiously as possible, preferably within period of 6 weeks from due
What
procedure
was
of
the annexure 1?
Annexed one is the order copy of Commissioner Consolidation.
What is the order of the Commissioner?
Order of the Commissioner Consolidation to record the land in favor of the government by deleting the name of private person. 90 dissimilar land, but they are not complied with total land.
Private persons were parties in the unit proceeding. Then
Private persons are not party, but order not complied for which
you come to the High Court and High Court passed an order. You want that to be implemented. So they should have been heard. They should have been heard. You want that certain the entries have been made in favor of some private persons. You came to the High Court. High Court gave a direction to Tahsildar to act in accordance with the order passed by the Commissioner of Consolidation. But in the meanwhile, they were not heard. Then what kind of the proceeding is this? After having considered the submissions made on behalf of the petitioner and an AGA representing the contemners in the court's opinion, no deliberate disobedience of this court's order is made out. So the order has been substantially carried out. So stop application. The contempt proceeding is accordingly dropped.
111.
11 non-execution of FR. FR as per direction in CRLMC, number 569 of 2020, court directed to that considering the submission made, petitioner is permitted to pursue the remedy before appropriate forum in view of the laid down by the apex court in Lalita Kumari versus court.
The petitioner has alleged disobedience of an order dated 1/7/2020 passed in CRLMP number 569 of 2020. Stop. In the court's opinion, the present contempt application is thoroughly misconceived and is dismissed accordingly.
112.
Dismissed accordingly as there cannot be said to be violation of any positive direction issued by this court. Yes.
112. All three cases. 113.
113 already complied.
Complied.
114.
On behalf of Mr. Patri, already complied.
Complied.
115.
That's it. Order dated 4/4/2019, passed in resolution number 7030/2019, having complied, having not complied or so. Order at page 9 or so.
Yes. My central law.
We have not received a copy.
As requested on behalf of the contemners, list this matter on 4 weeks.
116. 116 complied.
On appeal, we have the petitioner, then AGA states that this court's order has been complied with. The contempt proceeding is accordingly dropped. Yes.
117.
Non appears dismissed.
118.
18 it was the last time they asked for time. Order has not been complied by. Next year, one is the order. The relevant portion is at page 7. They were directed to consider the representation. So far it has not been considered.
There is no such orders. So order the very day, the first day the matter was taken up and it was disposed of. The petitioner alleges disobedience of court's order dated 17/5/2022, passed in WPC number 10306 of 2022. So the petitioner had a grievance that he was elected. He or she was elected as General Secretary of Both District Journalists Association, but was wrongly removed by an order dated 11/2/2022. Passed by whom?
Passed by the body.
So what the AD will do in that case?
It is the registering authority.
What is this?
Registering authority, my lord.
This the court disposed of the writ petition with a direction to the additional district magistrate board to consider representation filed by the petitioner. First off, the order was passed on the very first day when the case was taken up for admission without issuing notice to the concerned parties. First off, in such view of the matter, in my opinion, no case of willful disobedience of this court's order is made out. The contempt proceeding is accordingly dropped.
119.
Order dated 14th September 2022 has not yet been complied.
Where is the order?
Running page 12, Annexure 2, Para 7. Accordingly, this court, without expressing any opinion on merits of the case of the petitioner, disposed of the writ petition with direction that the event of the petitioner moved the appropriate application before collector Cutter within a period of 2 weeks. Hence, along with the certified copy of the order, he shall do well to take steps to see that the order under Annexure 2, Part in maintenance appeal number 41 of 2020 is implemented at an earlier date if there is no legal impediment.
So where is the order in maintenance case?
My lord, page 11 reflected this.
So who are you? Your husband?
I am the mother of the. I am the mother. I'm a victim of a parental abuse who has been evicted from her self-acquired property by her. My lord?
You are whose mother?
Mother of
ghost?
Mother, son is not a party in this.
Son is not a party.
Collected, he has a party.
Just see. See, order under Annexure 2 passed in maintenance is implemented. Without hearing other side.
No, already hearing.
No, in the petitioner has
was a party.
Disobedience of an order of this court dated 11/9/2022 passed in WPC number 18518 of 2022, whereby the writ petition was disposed of without expressing any opinion, with a direction to the collector Cuttack to implement an order passed in maintenance bracket in A number 41 of 2022 20. Comma, if any representation was made in this regard by the petitioner. Full stop. It is an admitted fact that the said order in maintenance bracketed A number 41 of 2022 was passed under the provisions of Maintenance and Welfare of Parents and Senior Citizens Act, 2007. Full stop. The progenies of the petitioner were not implemented as parties in the writ application. Full stop. The order was passed at the stage of admission without notice. Full stop. In such view of the matter, I am not inclined to entertain this contempt application, which stands disposed of. Full stop. Next. It goes without saying that the petitioner shall have liberty to approach appropriate forum.
And that appeal, that maintenance appeal has been challenged in the petition number 33349 of 2022. There your lordship has granted to maintain status quo. Already status quo is bracketed as because they took several times in the rate application. Already status quo bracketed.
The petitioner shall be at liberty to pursue his remedy before appropriate forum.
Item 120.
Your order of this honorable court has not been complied, and the annexure 1 is the order starts from page number 6. The operative portion is at page number 8. Paragraph 3 of the order, your lordship.
What is the order? Your prayer.
Your 3 was directed only to correct the record of rights, my lord. Only to take a decision to correct the record of rights, because the petitioner in view of this case number 50 of 2022, the same authority has decided that the petitioner is entitled for the land and the land should be corrected in his name. But the record of rights has not been corrected. So this court is only directed to within 3 months, my lord, let him.
Petitioner has alleged disobedience of an order of this court dated 18/7/2022, passed in WP number 17325 of 2022, which was disposed of on the very first day when the case was listed without notice to the other
State was the party. State was the party and state council was there, my lord.
State council was there, but state council was he did not do anything.
Yes, because the court has only directed to correct the.
No, your prayer was also innocuous. Innocuous means what?
Innocuous means, my lord, your lordship, but the court has held that this order is not against anybody, only directed to comply with. To take a decision on it. I have purchased land in 2000.
The court noticed while passing the order that the prayer of the petitioner itself was innocuous and directed the opposite party number 3 to the writ petition, the Tahsildar, Jatni, to complete the process of correction of records of rights within a period of 2 months. So, in the court's opinion, in the facts and circumstances and the nature of order passed by this court, no case is made out for initiation of contempt proceeding against the contemners. The contempt proceeding stands stopped accordingly. The petitioner shall have liberty to pursue his remedy before appropriate forum in accordance with law.
121.
My pleasure. Non-compliance of the order dated 18/4/2022 passed by this honorable court under annexure 1, my lord.
Yes.
Page 6 of is the order, my lord.
Propose prayer disposing of civil judge senior division to dispose of execution case.
My lord.
What is this? And who is to be proceeded?
Commissioner did not submit the report that civil court commissioner, my lord, contempt, my lord. That is the execution case.
So you want initiation of contempt proceeding against the judicial officer?
My lord, not a judicial officer, my lord. Civil court commissioner, my lord. He has to submit the report, my lord, before the civil judge senior division. Your lordship signed this annexure 2, my lord.
Annexure?
Annexure 2. Order.
What is annexure 1?
Annexure 1 is the order of this honorable court, my lord.
You are alleging violation of that order.
My lord.
See, read it.
My lord. Considering the innocuous prayer involving targeting the execution case number 19 of 2009, while disposing of the writ petition, direct the civil court senior division Champa to dispose of the execution case number 19 of 2009 within the period of 6 months from the date of communication of this order by the petitioner, provided there is no lawful obstruction by way of stay of such proceeding by the higher forum, petitioner is prevented from taking unnecessary adjournment in the trial court, my lord. Petitioner submitted the certified copy before the
Mr. Counsel, therefore, you want initiation of contempt proceeding against a judicial officer.
My lord. Then I filed the contempt petition against the civil court commissioner, my lord.
Civil court. What he was required to do?
My lord,
the direction was to the judge.
No, my lord. For the execution, my lord, non-civil judge appointment a commissioner, my lord, to submit the report, my lord. He did not submit the report, my lord.
The petitioner has alleged disobedience of an order dated 18/4/2022, passed in WPC number 9391 of 2022, which reads as under. First off, the writ petition was disposed of on the very first day when it was listed for admission without noticing the parties to the writ petition. Stop. In such view of the matter, comma, in the court's opinion, no case is made out for initiation of contempt proceeding against a judicial officer. Stop. The contempt proceeding stands stopped accordingly.
122.
22, 23, 7.
Same.
Same. Item 124.
124 non-compliance of order. Part on 13/11/2022. Direction to consider the claim the petitioner for payment of compensation.
Representation.
What?
Consider representation.
Yes, represent to consider the claim. Claim made for a payment of insurance amount under a scheme. Page 7 is the operative part of the order. Paragraph 4.
So this system have not been able to understand. So who was directed?
It was direct to Director Orissa Livelihood Mission.
Odisha?
Livelihood Mission.
Odisha Livelihood Mission was a party.
Yes, ma'am.
Odisha Livelihood Mission was noticed.
No.
About the petitioner alleges disobedience of this court's order dated 14/11/2022, passed in WPC number 29182 of 2022, whereby this court disposed of the writ petition the petitioner alleged in the writ petition that on the asking of insurance company to come through a nodal agency, the what is this? From the order, it transpired that the directions were issued to opposite parties number 2 and 5 who were not even noticed. Most often in such view of the matter, no case of initiation of contempt proceeding is made out. Contempt petition is disposed of. Yes.
125.
Lordship, the order has been partly complied with. Lordship ने खाली से page 17 अपना consent application. Property part Lordship.
17, yes. Partly complied with, and what has not been complied with?
Lordship, the amount of compensation has been paid, but the interest part that is 5% per annum, which will carry from the date of the presentation of the rate petition, that is not paid, Lordship.
Understand. Yes, who is for the other side?
Central government.
Union of India, Lordship. Central government.
Who is appearing? Who is appearing?
Mr. Padi appears. Yes.
There is no representation on behalf of the contenders. So shall we discuss this matter on next week.
126.
And 146, order has not been complied.
Yes, complied. Yes, complied.
Huh? Complied with? Tell him. Complied with.
127.
And non-compliance order dated 26/10/2022 meters. Petitioner is a farmer miller sold their paddy on 24/2019 meters. Till date, he has not paid millers. Till date, he has not paid his cost of the paddy millers. Therefore, he has filed a writ application. The matter directed. Further, it is directed that in the event any amount is found to be payable to the petitioner, the same shall be paid.
Where is the order?
Millers, it is the second contempt application, Miller. Because in the first contempt application, I have annexed 1 meters. This is the order.
Where is the order passed in the writ petition?
Because I have annexed in the past contempt application. This is separate order with me.
Yes.
Yeah.
On the very first day, the matter was decided.
No, because thereafter the secretary has said, I have filed a representation. The secretary has said that further I want to inform you that the transit pass from
Mr. Counsel, whether your representation has been disposed of or not.
because disposed of but the further the amount is not paid with us. Further directed to pay as has been directed my lord, the same has not been paid. Accordingly, the secretary has said that the transit pass from accountant note in PSS copy height number 123 dated 10/4 to.
Have you filed that?
Yes.
Have you filed what you taking?
First contempt application with us.
So what
It is the second
contempt petition I am required to read the first contempt petition.
Just copy with a continuous process with us. They have not complied the writ order. Thereafter, I have filed first contempt application. Neither directed and give another opportunity. Thereafter, they have not complied with us. Then second application. This is the order of the secretary matters and have that.
Yes, so what is your structure?
Cooperative society. Cooperative society notice.
Cooperative society was heard on when the order was passed.
Had the secretary of cooperative society.
Secretary of the cooperative society was heard when the order was passed.
Government advocate had
Government advocate is not this cooperative society.
because state is also a party with us. State food and civil supply department with us.
Let's miss the contempt. Who is the contempt?
The petitioner has alleged in the present contempt application disobedience of an order dated 31/3/2023 passed in WPC number 18730 of 2022, whereby the who directed whereby the secretary cum purchasing officer NAMI Service Cooperative Society was asked to consider the petitioner's representation and further, if any amount was found payable to the petitioner, the same was directed to be paid to the petitioner. Stop. The fact remains that the order was passed on the very first day when the case was taken up for admission without noticing the secretary, so and so, NAMI जो भी है cooperative society. So, in such view of the matter, in the court's opinion, no case of initiation of contempt proceeding is made out. This application, the contempt petition, stands disposed of.
All three cases.
Yes.
128. 128 complied.
Complied with.
Not complied, my lord.
128.
Order dated 3/5/24, my lord. Last order.
So they have
3/5/24.
complied with, this is what he is saying.
So that is all the compliance affidavit, my lord.
The order is there.
No, my compliance affidavit that was rejected, my lord. Order dated 3/5/24, my lord. I have a glance.
Rejected.
3/5/24 rejected. My lord. 3/5/24 order. Thereafter, they have taken time on 21/6/24. My lord has given 2 weeks time to comply the order. Delayed not now.
My complaint affidavit at 3/5/2024.
Compliance affidavit is of
3/5/2024, madam.
3/5/2024.
My lord.
Oh, but that was rejected.
My lord.
Seek instructions.
Well,
To the record.
Your lordship may call this matter.
I requested on behalf of the contenders, this matter on 2 weeks.
129. Matter of regulation, my lord, regulation of service, my lord. The opposite party direction has been made at and I have annexed the order of this honorable court at page 8, my lord. Direction has been given for regulation of service of the petitioner, but till date they have not taken it and they have not considered the opposite parties.
Where is the order?
Well, page 8, 9, 10, my lord, the orders. Last page 9, last para. It is relevant to note that in a similar case in respect of Angul Municipal, this court by order letter 27/11/14 in the writ petition such and such direct the opposite parties to regularize the service of the petition therein in view of the judgment of the apex court, Mahadevi and ML Kesuri. In the said order, the state of Odisha as well as Angul municipality prefer writ appeal which has been dismissed on 19/1/16 against the order dated 19/1/16 passed in writ appeal number 407 of 15. The state as well as Angul municipality filed
Have you considered?
Well, I'll take instruction in this.
Seek instructions.
has completed more than 28 years now.
Mr. Counsel, whether you completed 21 years or whether you were there for 28 days, no one had any opportunity to respond because the case was disposed of on the same day. It is your case that you continued for 28 years. I don't know what was in your case, it has been directed to be considered in the light of the Supreme Court's decision.
So far as
whether you were there for 28 days, 28 months, 28 years, don't know.
So far as other cases.
Let us see, 6 weeks time is allowed for the Portland AGA to seek instructions and file so-called reply. Let's this matter on 6 weeks. Yes.
130.
Your lordship, last occasion your lordship was directed to the state to take instruction with regard to, this is the third contempt, your lordship. The order under annexure 1, running page 16, your lordship passed in the writ petition. The opposite party number 3 in the writ petition, now the contender, has directed to dispose of my representation, taking consideration of annexure 4, which is a work certificate. Filed in that writ petition, work certificate is the work certificate issued to the present petitioner. What works he has performed discharge.
Number 3.
Chief District Medical Officer, Puri, your lordship. And in that writ petition, 3 weeks time is given, 3 months time is given to dispose of my representation. Till now, my representation has not been disposed.
So what can be done now?
Now I am doing.
What was your representation?
My representation to disburse my remuneration is in accordance with the work certificate submitted issued by the Chief Medical Officer in my favor, which has been announced in the writ petition. Till now, I am working there, and since 2021 to February 2019, I have not been paid a single time.
Where are you working then?
As the ECG mechanic. ECG mechanic.
Why are you working?
Under Jilla Shiksha Samiti.
Why are you working if you are not getting any salary?
I am working from 2004. Therefore, I am working there in order to, with a hope that I may be regularized in future.
But that was not your case.
And when the third contempt petition is filed, they have given 4 months time. And 4 weeks time, 3 months time.
In this case, there is a report from the CDMO. The lordship may call this matter on Wednesday. I'll take it because CDMO has requested the government to alert the payment. So, your lordship may call this matter
on behalf of the contenders. Let's this matter on next Friday.
131. On the last of it, in order to make payment of money,
on the prayer made by the State Council, your lordship, by your lordship's order dated 21/6/2027, granted them 2 weeks time and granted me the liberty to me to make a mention to your lordship to bring it to your lordship's notice. Here is the case, my pay has been fixed, but for payment of arrear, they have written letters to the finance department for necessary budgetary provision and this sanction order. Awaiting that, they had made this submission, and that is also they have included in the so-called whatever they have filed before your lordships in compliance with this order.
No, but they have complied with.
No, they have not complied with.
Let me see the direction.
Well, your lordship kindly see. The direction was to grant modify the approval order and accordingly release the. Your lordship, I have extended the order, the last part of the order. Your lordship kindly see. Para page 11, para 6.1. Considering such submission made by the non-council government AGA, this court directs the appellants, that is, state claim in appeal, to comply with the order passed by this tribunal dated so and so in GI case number so and so within a period of 3 months from today. And in compliance thereof, they have now fixed my pay. They have now fixed my pay under annexure A/3. And for release of salary, you will also kindly come to page 22 of the so-called affidavit. Page 22 of the so-called affidavit, straight away para 6. May I read, madam?
Please.
Madam?
Please read it.
Yes, madam. That as the total arrear bill of all the appellants comes to so and so, only we have written to the Director of Secondary Education Odisha to place the funds by letter dated so and so, the DO dated so and so. After receipt of the allotment, all arrears shall be cleared. With this manner, your lordship have been pleased to ask for instruction for compliance. Your lordship kindly come to your lordships. This honorable court's order dated 22/3/2024. 22/3/2024 order may kindly be seen. Third paragraph. 22/3/2024 order. Third paragraph. Basing on the instruction, additional government advocate contended that the matter has now been referred to the finance department for clearance and for payment of the arrear entitlement of the petitioner in question. Considering the request made by the learned AGA, list this matter on 26/4/2024. Thereafter, your lordship may kindly also see the subsequent orders and your lordship's order on the last occasion when government advocate asked for 2 weeks time for compliance for making this payment, and your lordship have been pleased to grant 2 weeks time or by your lordship's order dated 21st June 2024.
Yes. My lord, on 18/12/23, we filed a compliance affidavit before this honorable court. We have approved this service in accordance with the GIA order of the Education Tribunal, and we have fixed his pay. Now, after that, my friend has already submitted what has happened. Here, my lord, may kindly grant me only 3 days time. I will file an affidavit. There is an instruction I have received. There is a review pending. We will honestly pray, my lord, the review petition may kindly be taken out.
Since when?
My lord, it's pending since 23 from the order, date of order, after the order was passed.
Against this order?
No, not against this order.
Review
received the instruction.
Review has already been dismissed.
One review has been dismissed. Another review
this is the.
Please don't get excited.
One review has been dismissed. Another review is pending.
But against this order, the order which your lordship is now in session, my lord, with regard to compliance, they have preferred a review petition bearing RVWPET number 314 of 2023, which was taken up by the very same honorable court on 29/9/2023 and was dismissed. If your lordship permits, my lord, I can read it out.
No. What is the date?
The date of the order is 29/9/2023.
When did you file?
The other review petition 218 of 2018.
2018 he is referring to.
2018 of 2018.
218 of 2018.
When was the order passed?
In 2023.
The order
You can seek review.
no, this order was passed after the GIA order after the GIA, in the FEO the order was passed. But we have short review, so the instruction is not very clear. So I was praying for 2 days time because today morning I have received. Only 2 days time, so that I will be also clear. I have not been able to find out this review, 18 of 2018.
Next week. Yes, call karna. Criminal division, huh?
Okay.
Criminal legal matters.
But this matter will appear next week.
Pardon me, Lord. Item number 945, content matter, as the order has been complied, I want to kindly permit to withdraw this one with the liberty to 945. 945. The liberty can be done.
Additional special list. Item number 1, CRREV 234 of 2001.
Yes.
No, so conservation.
What is the conviction?
Conviction under section 376. And the conviction is 4 years and their final would be 500.
So what can be done?
Conviction for 4 years. Nobody is present. So you give you one opportunity, not does it turn out to not serve for the complaint.
To what?
So notice to be not either to not bring somebody or
And why a criminal division cannot be dismissed for default?
no, division can be dismissed. Appeal cannot be dismissed for the
Appeal cannot be dismissed.
So division can be dismissed for that is pretty much one opportunity next week if nobody comes up proceeding before.
But there is no representation on behalf of the commissioner. So from this matter on next week.
Item number 2, Item number 3. Item number 4.
Lordship, item number 4, Lordship. On behalf of Mr. Chatman, I pray, Lordship, the agreed petitioner challenging the order passed by London Additional Session Judge, Cambridge, Lordship. Lordship, petitioners were convicted under section 307 of 341, 34 of IPC, Lordship.
Yes.
Lordship. Lordship,
yes.
Lordship. Lordship, may I pray?
Right time, make an attempt. Make an attempt.
Lordship, kindly allow me to obtain an instruction from the client, Lordship.
So, it's very difficult. Difficult case for you.
Lordship.
I have requested on behalf of the petitioner, let's this matter on next Friday. So there is direct, so far as petitioner number 2 is concerned, there is direct allegation against you.
Lordship. Lordship,
And the
evidence proposed.
yes. And the injured has supported the prosecution case. Prosecution case. Then next.
Item number 5.
This is your lordship. But I am there virtually. With due respect, my lord, I have been briefed in this matter, my lords. But my problem is that the brief is not legible because of the fact that they are typewritten papers, my lords. With a flux of time, my lords, they have faded. So if your lordship will give me some time, I'll take a copy from the registry, my lords, and get ready in the matter and assist your lordship, my lords.
Next week, as requested.
Not next week, a week after. Next week, I have a matter at Raurkela fixed on Friday.
2 weeks. From Raurkela also you can argue.
No, my lords, I am there in a sessions case. I am filing a vakalatnama that may be taken on record.
Okay.